Hey guys, I'm sorry it took me so long, but I had to make an email, send an email out asking for permission. Haven't gotten the permission back from her yet, but I did send her a request. I mean, not a request. I did subscribe to her channel, and I also sent her emails asking for permission. And so if she comes to me and tell me no, I'm gonna wipe this live out. But I did put her in my subscription. I mean my title. So if she comes on and she tells me I can't use her content, we're gonna take it off and we're gonna continue the way we normally do. But I did ask for permission. So guys, just be aware of that, just in case we have to take things off. Just in case we have to take things off, we will do so, okay? So, I asked you digging me to come and put the site on our page so we can give credit to her, and also want to sow into her her channel. So I did send her email out asking for her Cash App to be a blessing, okay? Because I don't want to use people content unless I sow into their lives, okay? Hey Penelope, hey. So guys, if I have to wipe this out, I will. But I am going to give credit where credit is due, okay? So what she's gone over the R. Kelly case, and they started reading it like we normally do over here, where they took parts in reading the what's the name. So here we go. We're gonna I'm waiting for a couple of people to come on in. Come on in. A lot of people on. So I'm waiting for some folks to come on in. So come on in, y'all. Come on. We don't have much time, y'all. I think this is going to be a good one, y'all. All right, this is going to be a good one. All right, you watching and listening? Okay. All right. All right, so we're going to get started. I did shout out. And so we're going to subscribe. I just subscribed to her channel. So you guys are ready? You guys ready? You ready? Let's get started, okay? We're going to give a shout out to the owner of the content. We're using this for Fair Act purposes. Impress, could you please put my little disclosure out? And we're going to stop in between this live, and we're going to talk about it, okay? Which is very good because we were not there, so this will save us the money for the first one, so we'll be able to listen to this one because we already paid for our next one. So, all right. So just in case, I told her that we'll send her a donation to be able to use her content. So please subscribe to her. Her name is on my title. It's called Empowered Esquire TV. Empowered Esquire TV. Shout out to them. Copyright, thank you, Fair Acts Food. And we're going to basically review some of the stuff that's being presented, and it's not ours. So I'm going to go ahead and play. Y'all ready? Y'all ready to get started? All right, so we got 39 in the chat. Hey, K baby. Hey guys. Hey Black Beauty. You digging me? Okay, thank you. You digging me? Put it in the link. Guys, if you could subscribe to her, please do so. She did an awesome job on it. I just subscribed to her. So let's go ahead on and listen to it as a group, okay? All right, here we go, y'all. I think it's fantastic that someone was able to get this. Okay, ready?
Cases have said. One of the Supreme Court justices who was famous for being someone who said, hey, listen, judges should be strictly interpreting the law was Justice Scalia. May he rest in peace. But he was famous for saying that. He was famous for saying that he...
She seemed very, very, very knowledgeable. I give a shout out to her. Her name is Felicia Pearson. I emailed her to ask for permission to use this. So in between time, we're gonna go ahead and give a shout out to her. I haven't gotten an email back yet from her, but if we have to remove it, we will. But in the meantime, we're gonna listen to her. She sounds extreme. I would love to be in her class. All right, here we go.
Believes that we have gotten to a place where judges are being too liberal with their, interpretations of the law. Okay, so anyway, nerd moment.
What's going on that they say that she's actually one of the top judges that run by the book. She runs by the book. She's a great
Okay,
judge.
Divine Diva is in here too. Divine Diva Light.
By the law. She don't play no games in her courtroom.
Good to know. Good to know. So Diva and I are going to kind of give you the introduction into this transcript before we jump into what evidence was actually admitted and what evidence was found to be inadmissible. I've actually gone through this transcript and highlighted for us each piece of evidence. So Diva and I are going to read pages 1 through 7, I believe is what we said, or 1 through 10. I think
1
we said
through
1 through 10.
Yeah.
And I'm going to be the court. She's going to be everyone else. And we're going to get an idea for how we got to where we are. So we know the government was present, right? We know that. And then on behalf of the defendant, we know that Canick was present, right? Devereaux L. Canick. We know that Farinella was present. I believe that Nicole there we go. Nicole Becker was also there. And it looks like Calvin Scholar was also there. Okay, so we know that the government had 3 ASAs there. They had Geddes, Melendez, and Shihata. And then we know that pretty much the entire Kelly defense team was present. Okay. So Diva and I are going to start.
Okay, and this is her name is Felicia Pearson. She is the person that's she's called the Empowered Esquire TV. Anybody that would like to subscribe, you digging me? Just put in the link for you guys to go subscribe. I'm using her content. This is her content. I'll give her full credit for this as well. Thank you. You digging me?
Our reading here on page 3. So here I am at line 2. Everybody can have a seat.
This is criminal cause for a pretrial conference docket number 15 CR 286 USA versus Robert Kelly. Counsel, state your appearance. Government first. Ms. Geddes, Elizabeth Geddes, Nadia Shihata, and Maria Cruz Melendez for the government. Good morning, Your Honor.
Good morning.
Mr. Canick for Mr. Kelly. Devereaux Canick, along with Nicole Blank Becker, who was appearing remotely, Thomas Farinella, and Calvin Scholar. Good morning.
Good morning, Mr. Scholar. Welcome aboard.
Good morning, Your Honor.
A couple of things to take care of today. I'm just going to remind you before we go into the motions in limine. Let me first ask Ms. Becker, are you staying with us on the case?
Thank you, Judge. Judge, I did. And I hope you received a letter this morning.
Yes.
From the doctor?
Yes.
Did you get that, Judge?
Yes.
Okay, great. Yes, Judge. Based on the doctor's assessment, as of today, I am allowed to travel. So I will absolutely be there.
Okay, great. All right. Second thing, jurors have been, so just related to what Ms. Becker said, I take it you're no longer requesting an adjournment. Is that right?
We're up and ready to go, Your Honor.
Okay, good. The second thing is that I'm sure you're all aware that jurors have been filling out questionnaires. And so, as I directed earlier, we need to have your list on those jurors upon whom you agree, the ones that.
Okay, shout out to Empowered Esquire TV. Go those who are not subscribed to that person, please subscribe. This content is hers, and I just want to give a shout out to her for this content, okay? Because they have this transcript from the August 3rd, okay? This is going to be used for Fair Practice Act, and we're going to discuss this after we listen to what is being played. Gucci, whenever you're ready to come on board, come on, okay?
You agree should be excused. We need to have those tomorrow. So the ones you agree should be questioned, and the ones that you agree should be excused, and then I'm sure there will be some that fall in the middle. We have to have that by tomorrow. Just in terms of the trial schedule, it's my plan to take Fridays off, except for those weeks where we have holidays. We have a number of holidays in September, religious holidays, and so the weeks that include a religious holiday, we'll work on the Friday that day, and I don't have them at my fingertips, but I think they're pretty easy to find, okay?
Your Honor, to be clear, the Friday before Labor Day, we're off?
Would you like to be?
Yes.
Well, I don't think there's anything else that week.
All right.
That's Kanik talking, y'all. That's Kanik talking, and she's giving them the time off. Hold on.
So yes.
I apologize. I'm Blank Becker. I apologize, Judge. I can't hear Mr. Kanik speaking. I can't hear him.
Okay, just let's be mindful.
Sorry.
That's okay. Just be mindful of the microphone. Mr. Kanik was asking if we had the Friday before Labor Day, and I don't think there's any other holiday that falls then. So the answer is yes. So we'll have that.
Ms. Geddes, and Your Honor, I'm sorry to interrupt.
That's okay.
Will you also sit on August 20th, since we have a short week that first week, Friday the 20th?
Is it a Friday?
Yes.
I think it's a good idea to make as much use of our time as we can, so yes.
Thank you.
Okay, so she's asking, is the judge going to sit? This is the government's asking, is the judge going to sit on this coming Friday, which is the 20th? Because she says every Friday they're going to be off, like when a holiday, unless the holiday falls on that Monday. So Labor Day, Kanik asked for that Friday off, so they're going to have Friday off on Labor Day week. But all the other ones, they're going to be off, with the exception of this Friday. So the trial is going to be Wednesday, Thursday, and Friday this week, and then the other ones, it's going to be off every Friday. Okay, just want to tell you that. Okay.
Okay, now I just want to go through the various motions in limine. Some of, at least with respect to some of the submissions, are under.
Okay, yeah, I just got to be very careful listening to what is being said. Okay, I'm gonna stop it in between because I want us to use it as a learning point. So I'm gonna stop it in between so we won't get struck. Okay. So, but I did ask for permission from her. I didn't get it yet, but I wanted us to listen to this. So let's see. I do have a notification. Hold on a second. Let's see if I got approval. Not yet. So, but I did send her a message. All right, let's go.
Seal. And so I'm just reminding the parties to be sensitive to that. I'm going to begin with the government's motion to admit various acts that are not charged in the indictment, but that the government asserts are evidence of the pattern of racketeering. And just as a reminder, the time frame for the pattern of racketeering is from 1994 to present. Mr. Farinella, in your objection, there were just a couple things I want to clarify, because you're saying that you had insufficient notice under 404B. I mean, that applies to when the government is just seeking to admit evidence of bad acts, which is really not what they're seeking in this case. But you've had the discovery material and 3500 material for quite some time, which includes the materials to which the government refers. You're not saying you didn't get the material, are you?
I guess Diva forgot she was Farinella. She's waiting on her. Diva forgot you.
Diva, Mr. Farinella.
Oh, I'm sorry. I didn't realize I was muted. I was talking this whole time. Sorry, guys. Okay, I'm Mr. Farinella. Your Honor, what I've said in the motion is that the incidents that they are attempting to introduce into evidence, the 3,500 material related to those specific incidents, were provided just recently.
February, I thought.
Well, there was an additional disclosure made on or about last week. This week, Monday, with additional 3,500 material relating to these acts.
How many of them? All of them? I think you have to be specific. If you're claiming you were blindsided, which is what you said, so what specifically did you not get until recently?
Well, Your Honor, we only obtained the additional John and Jane Does, that information yesterday at the time.
Do you mean the names of them?
There's an additional 17 Jane Does, and there are 2 additional John Does.
I just want to make sure I know what we're talking about. I'll go through each one, but my recollection, and I actually checked the docket sheet before today's appearance, was that the representation by the defense was that you knew who all of the Jane Does were. Are you saying that's not accurate?
So, Your Honor, I'm not saying that's not accurate. That is in fact accurate.
Okay.
In the underlying indictment, Your Honor, there are.
Okay. I'm not trying to pick on Farinella, but you guys listen to what he is saying and listen to what the judge is asking. Okay, listen to what he's saying. Listen to what the judge asked. The judge asked him, "Are you saying that you didn't get all the names, or are you saying that you got it, but you just don't know which name belongs to which act?" Or just listen to what she asked him.
6 Jane Does. We've obtained the identity of those Jane Does. However, in the government's motions, they have unveiled 17 more additional Jane Does and 2 additional John Does. Oh my God, you hear me?
And are you saying that you didn't know the names of them until recently, or that you didn't have any information about the acts that are connected to them?
To the extent, your first question, Your Honor, the names were only revealed to us, the actual specific names as to each of the Jane and John Does actually provided to us yesterday.
Okay, is that accurate?
No, Lady Gemini, you said this person the judge is talking to is clueless. Lady Gemini, behave. That's Farinella. That's Farinella she's talking to. Lady Gemini, behave, okay? Okay, Elizabeth, what's wrong with y'all faces? What's going on? Thank you, Ruby. Hey, hit the like button now. Hit the like button. Okay, let's continue to play it. You trying to behave? Shout out to Esquire, to Empowered Esquire TV. Shout out to them for their for the content. Oh God, stop it. Okay. It sounds like he doesn't have a clue, right? Okay, hold on. Thank God for Kanik. That's all I got to say. Thank God for Kanik. Oh, Jesus. Oh, Lord. That's all I got to say. Thank God for Kanik. All right, let's play this.
I want to ask the government.
Ms. Geddes, we provided a full disclosure of every name of the Jane and John Does yesterday. In addition, we had provided the names of several of those Jane and John Does previously, but we didn't identify them as John Doe or a Jane Doe because there wasn't a motion related to them. We just disclosed their names previously to defense counsel in the 3500 material.
So
What about the underlying acts?
So they basically saying that in the 3500 material, they gave all of the information that was in there. They just didn't pinpoint John Doe, Jane Doe, because they didn't put a motion in about them. They put a motion in just recently, so now they can apply which John Doe it was to which act. But all the John Does were already in this, and Jane Does were already in the 3500 material. That's what they basically saying. They just didn't outline which one is when because they weren't going to use them. Now they decide they're going to use them. Now they said they disclosed which one was which, but the information was already in the file. That's what they're saying. Okay.
The underlying acts were the subject of 3500 material disclosed in February, with the exception of, I'm looking at them right now. We did provide some additional 3500 with respect to Jane Doe 11 and 12, which we obtained after the initial February disclosures. So we provided that more recently.
Okay, so they're saying for 11 and 12, they didn't have the information until after February. So they just recently submitted that. So that could be a problem on that one. Because if they had it and they didn't disclose it when they had it at the time, that could be a problem. But all the other ones, they saying that it was already included in the 3500 material, with the exception of 11 and 12. Okay?
Okay.
And we provided additional evidence of some of the other acts, evidence that we seek to admit. But the 90% of what we seek to admit, we had previously disclosed the substance of those allegations in 3500 disclosures and discovery disclosures.
So you acknowledge that, don't you, Mr. Farinella? That you had the substance of what these claims are?
Yeah, I mean, to the extent they were provided, yes, in the 3500 material.
Okay, but that's what I'm trying to figure out. What are you saying that you didn't know about, that this is a complete surprise to you? Anything, or is it just that there's additional? Okay, so the choices are, I never heard this before.
Wow.
I heard part of this before.
Wow, y'all. Doesn't that sound like she has to go through the elementary for him? Oh, wow. Wow, that's not cool, y'all. Listen to this. It's not cool. Listen. She has to go like break it down like layman, like for us, like us regular people. Cause me, I couldn't understand it, but for him to be an attorney, for her to have to break it down like that, ooh, ouch. Look at your face, Elizabeth. I see that face of yours. I'm feeling the same way. Hold on.
But I didn't have all the facts in connection with it, or I've heard the whole thing before.
She ain't playing with him. Mr. Farinella says, I think your second choice, Your Honor.
Okay.
Did he just say, I think your second choice, Your Honor? Wow. Okay.
I've heard it to the extent, but there was no connection to facts and to the actual witnesses themselves.
So you just didn't know the name of the person that was associated with the particular allegation?
Well,
you know, let's go through them all, because that's what I'm going to do anyway, and then you can tell me.
Oh, wow.
The other thing I'll say about notice is that I'm the one who set the motion schedule for motions in limine. And
now you see how she has to explain. She says, I'm the one who set the schedule. Basically, if it was a problem before, why didn't you say something? Lord Jesus, Father. Oh my God.
I don't the only thing I recall about that is that the defense asked for extra time, which I granted. So that was what the schedule was. And if there was some need to have it sooner, I'm sure you would have told me. All right. So what I'm going to do is just go through these. And if I miss one, because I did get a lot of submissions, I'm sure you'll let me know. So the first one has to do with the claims related to Jane Doe number 1. And these allegations are about conduct in 1994. The government's position is that this evidence is direct evidence of the enterprise, that it provides the motive for the charge in racketeering, for the conduct in Racketeering Act 1, and that is inextricably intertwined with that. And so it's clearly relevant. And it clearly shows a motive for Racketeering Act number 1, and so that is admissible.
So she's saying the Aaliyah thing, the racketeering part is admissible. Okay.
So pause for a second. We've gone through page 1 through 10 of this transcript, and as you can see, Judge Donnelly is spicy. Okay, she is not a wallflower judge. She's not a sit-by judge. She is very much into what's going on. She's active. She's read and reviewed everything. And it appears that Attorney Farinella has been making this argument of the government withholding evidence, the government withholding materials.
I like the way she's explaining it. This young lady, I really like her explanation, how she's explaining this. She's really good. So she's gonna break it down for us, okay? She's gonna give us hope. I heard this already, but she's gonna give us hope. That's what I was doing earlier when I didn't come back to you guys. I was listening to her providing this to her. But she's gonna give us hope, y'all. Sean, don't do that. Sean, please don't do that. She's gonna give us hope, okay? Hold on.
Not telling the defense team who the witnesses are. And if you're not new here, you know why he's doing that, right? And I think also the people from Diva's channel probably. But if you're a newbie here, let us tell you why he's doing that. He is setting up an appeal, right? He's setting up an argument that R. Kelly's constitutional rights were violated in some way. And if, again, like I said, if you're new here, there are certain pieces of evidence. Some jurisdictions refer to it as Brady, right? There are certain pieces of evidence that if the prosecution does not turn it over within a certain time, you don't even need to worry about an appeal because you have a mistrial. You have a dismissal right off the bat.
You heard her, right? So if they have not I am giving you hope, but listen to this. She's basically saying that Farinella is setting up the stage that if they have to go to appeal, there's going to be a guaranteed appeal because his rights are being violated. He's basically saying that they did not provide all the information for them to be able to work this case, right? And she also said that if everything is not done correctly, it's going to be a mistrial anyway. Okay, so she's giving you some hope. Okay.
So Farinella is already going for that. He's already using certain terms and saying evidence being withheld, and he's using all the buzzwords to try to set that up. But you see that Judge Donnelly is having none of that. She pretty much, I set the schedule for disclosure. I told you when to disclose things, and the government disclosed things when I told them to. So you're not going to come in here and tell us that it wasn't disclosed within a timely manner because I am the timely manner. Got it?
Exactly. She's not playing with him or his team.
What are your thoughts thus far?
Yeah, she's not. She's definitely spicy. I like her a lot. In the R. Kelly sector, we call her Auntie Anne. She is not playing that. And I think, she sees the little games that they're playing.
No, but watch
why she acts.
Watch what the ladies say. Watch what Felicia say. Watch what she said. There's still hope, y'all. Please don't think there's no hope. Please don't do that. Just watch what she think. Watch what she tells Diva Divine. Hold on.
20 different ways. You better not be saying what I think you're saying. So make sure you correct yourself. Dot your I's, cross your T's before you try to say that the government's withholding stuff, because then they could get in trouble for that. Correct, Ms. Pearson?
Absolutely. As we just discussed, Attorney Farinella, and truth be told, he's just doing his job, right? He's just doing his job.
Right, defending.
He's setting up a potential appeal. And if he can do even better than the appeal, like I said, if he can get some sort of mistrial or dismissal, he's going for that. So he's already setting up evidence being withheld and witnesses being withheld, but Judge Donnelly is not, she's not having it. She's not letting it happen. I'm going to take a second and say what's up to some people. Hello to the entire OCOV family. I honestly don't know what that stands for, but
one color, one voice.
I like that. All right. So hello, OCOV, to the whole fam. Hello. Hi, Karen J. Hi, Karen A.
Look, y'all, we're gonna go over there one day and sit with her. I'm gonna send her.
Take R. Kelly.
I'm gonna send her a thing because she's an attorney. So we're gonna go over there one day with as a group. Okay, we're gonna go to So I'm gonna reach out to her and ask her if we can do what they did. Go over there, talk to her, because she is an attorney. Okay, she seemed like she's a teacher. So they went all over there. Okay, she said, please understand, regardless, Phoenix Rising said, Phoenix was over there. Phoenix didn't even tell us about this lady. Please understand, regardless of what the paperwork say, it is in the hands of the juries. Understanding experiences and opinion, you can be oversaturated with information. Okay, here we go. Thank you, Phoenix.
Let's see. I think everyone else in here is OCOV. OCOV is strong, huh? You guys are a strong fam. All right, so we're going to get back into the transcript. And what I've done now, so that we don't have to go through, because Diva will go through the entire transcript on her channel. So if you really just want to sit and listen to the entire transcript, you can get that on her channel. What I've done is highlighted all of the important moments as far as what evidence was admitted and what wasn't. So whenever you see pink, that is something that was in the favor of the government, right? Whether it was something deemed to be admissible or inadmissible. Whenever you see something blue, yes, go ahead.
Guys, so that means that Auntie Anne will be admitting the bribery charge with Aaliyah, which is Racketeering Act number 1. So that's what's being admissible. So those people on the other side saying that they threw it out, that's a lie.
All righty. So whenever you see the evidence highlighted in pink, you know that we're about to discuss something that was in the favor of the government. Whenever you see it highlighted in blue, it's something that was in the favor of the R. Kelly defense team. And whenever it's just a simple yellow highlight, you know that it's just a teaching moment. It's just a conversation that we're going to have for our own enrichment. And of course, I'll be stopping along the way for Diva to chime in. All right. So let's dive in. So our next piece of evidence comes up around page 16. Here we go. We're here. I'm going to start up here at line 1. Okay. So, well, actually, you know what? Let's go back to here. Here we go. So we are here on page 15 at line 18. The next request has to do with Jane Doe number 8 in 1994. Pause. Diva has already prefaced for you that it is believed that Jane Doe number 8 is who? Aaliyah. Okay. The next request has to do with Jane Doe number 8 in 1994. The government proffers Jane Doe number 8 was in a concert of the defendants and was directed.
No, number
that's
1
not.
is Aaliyah.
That's not number 8.
Number 1. Okay.
Number 8 is not Aaliyah.
Wow. Anyway, I'm not even going to go into
another girl. Yes.
Right, I'm not even going to go into how many Jane Does there are in this case. Wow.
It's another girl. Definitely another girl.
The next request has to do with Jane Doe number 8 in 1994. The government proffers Jane Doe number 8 was in a concert of the defendants and was directed to go backstage by the defendant's associates, and that the defendant then had sexual contact with her. As the government has proffered before, they represent that this is direct evidence of enterprise and its means and methods. This is an example, and maybe I don't have to repeat it, but this is really not propensity evidence. This is evidence that is offered to show the existence of the enterprise and the methods undertaken to perpetuate the evidence. So it is relevant, and it's not unduly prejudicial. It's no more inflammatory than the charged offenses, and so that one is admissible. So you guys,
Okay.
what just happened there is that Farinella and the defense team tried to get an encounter from 1994 deemed to be inadmissible. Now, as Diva just told us, this is not Aaliyah. So what does that tell us? There's more than one Jane Doe from 1994 that he's being charged with. Wow. They talk the allegations, and then the judge gets into the legal stuff. So let's discuss the legal jargon. Judge Donnelly says it's not propensity evidence. So remember when we had that conversation about a prosecutor cannot say that because you did something yesterday, you've done it today. That is propensity evidence. So a prosecutor cannot say, because R. Kelly did whatever he did, on Monday, we know he did it on Friday. No, that is propensity evidence. And the judge is saying, this is not propensity evidence. She's saying this is actually evidence that tends to show that there was an enterprise, which means this evidence is not relevant in regards to whether R. Kelly did something in the past, but rather it's relevant because you have allegedly someone who is plucking these girls out, right? Allegedly, and bringing these girls to R. Kelly. That is an enterprise. So you have Judge Donnelly saying, listen, this is relevant, not because of propensity, because of the allegation of there being an enterprise.
Now, Miss Esquire, can you, this is a racketeering charge, right? Mm-hmm. So they usually charge, for mafias of that nature and gang members and things of that, right? So they're trying to say that as an enterprise, he worked as like a mafia because he was the head CEO and had his commission and then his soldiers. Kind of.
Right. So the key term is organized crime. So when you're talking about the gang, you're talking about the mafia, the law looks at those types of criminal organizations as organized crime. And that is the allegation here. The allegation is that R. Kelly had allegedly an entire a whole criminal organization, which purpose was to solicit girls that he would then allegedly abuse in a sexual manner. Now, side note, usually I don't use that word on this channel, but we started very, very early with using the word. So I figured, why play games now, right? Right. So the allegation.
She used the words that she's following.
It was a criminal organization. It was not just R. Kelly choosing these girls and then soliciting them. He had an entire setup, an entire scheme of people who would pluck girls for him and bring them to him for the purposes of allegedly having intimate contact with them.
Now, my other question would be, why do you think that, because there's also the obstruction of justice case, right? And they are alleging that Daryl McDavid and Milton Brown were the managers, so they're part of the enterprise. I want to make sure that the people out there understand that why is R. Kelly the only one charged in the New York indictment under the racketeering law?
So what we are discussing in this case is the trial of R. Kelly, right? So just because you hear us discussing R. Kelly's prosecution does not mean that other co-conspirators were not prosecuted or have not already pled guilty to certain charges. We're discussing R. Kelly, yes, but that doesn't mean that no one else was charged.
Do you think that these other people that might be charged will, their indictments might be unsealed or of that, because they usually seal indictments and collect evidence, stuff like that, and so they're ready to unseal it, correct?
Right. So these types of cases, the documents tend to be sealed because it involves minors and it involves, really sensitive allegations and things like that. It could be unsealed. So, for example, if, let's say, some of these co-conspirators are testifying in this trial, which I believe that might be the case, right? Then it's possible that the documents pertaining to their case is going to be unsealed, because I'm almost certain the defense will say, those documents should be unsealed.
Right. I want to know who are the other people that you're charging. You say he's
Okay, Sean said, y'all better listen to me. The judge is all in with the government. God bless her soul, but Aaliyah is not here to testify. That is it. This is true. So what? That shouldn't have been in the case. BS. But remember, they're using Demetrius as direct. They call it direct witness. That's what they're calling him, direct witness, because he was there when when the stuff happened. He's considered direct witness. So that's why they're using, because Demetrius said he would testify of what he directly witnessed. It's not hearsay.
an enterprise, but why is it only one man being charged, right?
Right. And so, as we've just discussed, R. Kelly is the person on trial in this trial. It does not mean that he is the only person that was charged. I'm going to say it again. R. Kelly is the person on trial in this trial. It does not mean that he is the only one that was charged. There are several things that could have happened. Co-conspirators could have pled guilty, or co-conspirators could be having separate trials. Co-conspirators do not always have the same trial.
But why they're not mentioned?
Because Daryl McDavid.
But my question is, why isn't the co-conspirators mentioned? Why isn't all co-conspirators mentioned? Dom, you did the same thing I did. I went and listened to her too.
Are in the obstruction case in Chicago, and then the three guys who were
they had nothing to do that.
Intimidation on his behalf, allegedly. Two of them pled guilty, and one of them is going to trial.
Thank you for that update, Diva. So you see, per the information that Diva receives, it appears that the co-conspirators are moving along in their cases, right? So, So
wait. See, this is the thing that's bullcrap. The co-conspirators, so they saying Don Russell is a co-conspirator. They saying Williams is a co-conspirator, and they saying Arline is a co-conspirator. That doesn't make sense. This is some bull.
Trial, you're not always going to trial with whoever your alleged co-conspirators are. They may have their own thing going on for their charges. Okay?
Right.
All righty, so we are going to...
Yeah, this is some bull.
The transcript. I just want to quickly mention, when you see here at line 5 about this evidence not being unduly prejudicial, that is something we've also mentioned. Remember that evidence has to pass through the probative value of the prejudice standard. And so Judge Donnelly is saying, listen, this evidence isn't any worse. It isn't any more prejudicial than the actual charges themselves. So it meets that goalpost. All right, let's see here. Now we're on page 18 with yet another piece of evidence. All right, so I want to make sure that we know exactly what evidence we're discussing. So I think we're going to need to start here on page, 17, up here at line 12, okay? The next item refers to Jane Doe number 10 in 2001. This is similar or somewhat similar. It's related to the previous one, but it also, that was a mistake on her part. This has to do with Jane Doe number 10 being recruited by an associate at a concert when Jane Doe was 16. And at some point, Jane Doe became concerned that an encounter with the defendant was filmed, and so that she reached a settlement with the defendant on that matter. Now, this is not one of those things about which you didn't know, is it, Mr. Farinello? And then Mr. Farron.
Okay. Brown and McDavid, they're not part of the case in New York. That was mentioned in Chicago. That's what the prosecutor and the judge said. They were not part of the case in New York. So the three that they're talking about is the three: Don Russell, Milton. I mean, not Milton, Arline, and Williams, which we know had nothing to do with this case. So we know that's bull.
Says that he's reviewing it, and they have a whole back and forth, right? And then Judge Donnelly says, so the question is, well, I don't think there's any question as to whether or not it is relevant, because it, again, is evidence of the enterprise and its means and methods and settlement. The fact that it was settled, I think, is evidence of the effort to perpetuate the existence of the enterprise, because were that made public, it would certainly have jeopardized the existence of the enterprise. She then says, so it is relevant. It is not unduly prejudicial, because it is, like some of this other evidence, no more inflammatory than the charged offenses. So it is admissible.
Woo, another win, guys.
So here's what all of that means. If you go back to page 17, they tell a little story, right? A little allegation of a Jane Doe who was about 16 being picked again by an R. Kelly associate. So when you hear Judge Donnelly saying it's relevant because it's proof of the enterprise, she's saying it's relevant because it's proof that they were working together. They were working in concert, allegedly, and it proves that, which makes it relevant. She then goes on to say that they eventually settled with this young lady, and she said that is relevant as well. She said that the settlement is proof that there could have been an enterprise, because the motivation to settle is what? I know that in fact I'm somehow liable and I would like to avoid full liability. That's why someone usually settles. So she's saying, being that they settled with this young lady, they honestly are insinuating that they were an enterprise, and that's relevant.
Right.
So government will be allowed to discuss this 16-year-old girl who allegedly had an encounter with R. Kelly, and they will also be allowed to discuss the fact that R. Kelly then allegedly paid her a settlement.
Y'all, it's the people that worked. It's the people that was around him did this, y'all. It's the people that was around him. 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 They went and gave this information. They're the one who saying this has happened. Wow.
Not to discuss what happened. Okay? Anything on that, Eva?
These are girls that I don't even know who to connect this one with. So a lot of these girls are girls we don't know.
Very, very interesting, because Diva and her people are on it. So for them to say that they're not even aware of who this is, that just goes to show you that the government had a lot up their sleeve. All right, next evidence. Well, actually, our next thing is a teaching moment, not even evidence. All right, so we're here on 19, and we're here at line 3. The court says, and I should have said that at the beginning, that there are many instances that I've ruled that are admissible that will require a curative instruction should the parties request it. Okay, so here's a teaching moment. What Judge Donnelly is saying is, listen, yes, I am ruling a lot of these pieces of evidence to be admissible, and yes, they will be discussed at the trial. But if it harms either party, they can request that I have a conversation with the jury in which I make sure that it does not do an enormous amount of illegal or unnecessary harm. So what she really means is, let's take, for example, with a lot of these Jane Does, right? The defense attorneys could and probably should will request that Judge Donnelly have a conversation with the jury in which she says, now, ladies and gentlemen of the jury, when you hear about these Jane Does, you are not to consider whether or not R. Kelly actually had intimacy with them. Don't consider that. What you should be considering is their testimony regarding their interaction with other members of R. Kelly's team And the allegation that those members then brought them to
Okay,
R.
K
Kelly,
baby.
that is it. Right? So that's just an example of a type of curative instruction that could be provided. So defense attorneys probably will do that. They probably will say, Judge Donnelly, for some of these accusations, we need you to explain to the jury what they're considering it for. Okay?
Okay, so they're allowed to only speak about their experience with the enterprise, not about the sexual experiences. Correct?
Absolutely. That is correct. And I am going to go ahead and mod some people in the chat. Yeah, unfortunately, I see that there are some things going on in the chat that, you know what, maybe not necessary. So what I'm going to do is go ahead and mod, and let's have a quick little combo. This is a space where we are unbiased, right? So I do not come onto this space to express my personal opinions. I come onto this space, I read transcripts, I explain the law. If you do not like what the law is, I'm sorry. But that is not my personal opinion. That is the law. And you are open to have a personal opinion that's different than the law, right? That's totally cool. But when you're in the chat, be respectful to everyone in the chat. And that's for both sides, right? Everyone be respectful to each other. Because at the end of the day, you guys, we are having a conversation about what is happening to someone else. You are not Kelly.
That's
Okay,
right.
so
Tell him. Tell him.
Find yourself so involved with his life that you're being disrespectful to other people.
Thank you. She's telling them.
Thank you, guys. Mod me, Miss Esquire.
Yeah. So I modded Take R. Kelly and Blade as well.
Mod Blade.
I just modded you.
Thank you.
And then I modded Blade as well. So we have some mods. So you can have an opinion that's different than maybe most of the people in the chat. That's cool. But do it respectfully, because we're
no disrespect. No disrespect.
Okay?
No disrespect.
All righty. And as Michelle Jordan said, please don't take it personal. I mean, my goodness, R. Kelly's the one on trial, not you. Okay? All righty. Let's get back.
A bunch of heathens in here. Hello.
We are going to find the next evidence. So here we are.
She's letting a lot of it in.
27. But we're going to roll it back to page 26 because we want to have a conversation about what this evidence is before we go into it, okay? So here we are on page 26, line 10. Mr. Farinella says, Your Honor, also just to ensure for the record, we have not been given any specific information as to the various employees and witnesses that have been identified in terms of specific references as to who they are. And the court says, have you given the names of who employee number 1 is? The government responds, we have provided 3,500 material for each of these employees, which include their first and last names. The court then goes on to say it might not be a bad idea, just given the volume of information, to give them a list. Okay?
So she told him to give him a list. She told him to give him a list.
Then goes on to say, if it's not clear, that is admissible and relevant evidence. Pause.
Okay.
Donnelly is saying that any argument that the government wants to make about employees of R. Kelly's who are allegedly involved in this enterprise is relevant. Now, defense team tried to argue that certain conversations about certain employees aren't relevant because they're disgruntled, but that's not relevance, right? So let's have a quick teaching moment.
Right.
Whether or not a piece of evidence is relevant is whether or not it speaks to a material, and material means important, fact in the case. So when they're talking about, this person is disgruntled or this person had quote unquote beef with R. Kelly, that doesn't make the person's testimony irrelevant. That just means that the jury should be told to consider that when they're weighing the credibility of the witness. We talk about credibility a lot. So your history with someone is something that could make you either a more credible witness or a less credible witness. But it does not make your testimony irrelevant.
So that's being put in. Don't get mad.
That's being brought in. Again, you guys come on. This is a transcript. Judge Donnelly said this. getting upset at people in the chat about what Judge Donnelly said is asinine. Okay. All right. So let's move on to page 28. So now we're talking about more evidence. So actually, we have to run it back to page 27. And start here at line 16. The evidence, according to the government, is that Mr. Kelly began a sexual relationship with Jane Doe number 16 when she was either 16 or 17, and that she stayed with him until 2017. Okay, so that's the evidence. She then goes on to say, this is direct evidence of the enterprise's means and methods, and particularly over that long period of time. So it is surely relevant, and it is surely admissible for the purpose of being direct evidence. So again, we have yet another Jane Doe. We have that she had a long-standing relationship with R. Kelly, allegedly. And we have the defense team trying to say it's not relevant. And we have Judge Donnelly saying, well, actually, if she was with him over this period of time, she had to have interacted with other quote-unquote members of his team, which makes it relevant to whether or not there was an enterprise.
Right,
So,
the handlers, right, the handlers.
So they get to bring that in as well, okay? And if you're noticing that we've seen a lot of pink thus far, yeah, that's right. Okay, so then she goes on to say
she's letting a lot in.
Evidence, her same language, is not more inflammatory.
She's letting a lot of those stuff
charges.
in.
So what she's saying is, again, it's not more prejudicial than the actual charges. They're accusing him of having an enterprise which took intimate advantage of young women. And this young woman is alleging that he took advantage of her. It's par the course for the charges, is what Judge Donnelly is saying. Diva, do you have anything you'd like to add before I keep moving?
So the charges are more offensive than the actual crime itself?
No, she's saying that these allegations, this testimony, is not more prejudicial or more inflammatory than the actual charges. So she's saying the testimony would just be exactly what's already in the indictment. Right. It's the testimony.
Right.
It's what you're already charging him with. So you're not saying anything that would be any more horrible than what he's already being charged.
Than what he's facing. Right. Got it. Okay. Auntie is not playing. She is not. She's like, listen, y'all got to understand that we're playing connect the puzzles. And if this puzzle belongs to this other side and it connects, it's got to go in because it fits.
Exactly. And she is really, really not. She is on it. And for those of you who think that thus far she's behaved in a biased manner, I assure you, she has not. She has not. Everything she's saying is spot on legally. When you have a case, when you have a case with allegations of intimate crime, all of these things are going to be relevant. When you have a case that's alleging that there was an enterprise of human trafficking, and all of these things are relevant. So she's not being biased at all. She's right on point with these rulings, in my humble opinion. All right, let's keep it rolling. We're on page 20.
Excuse me 1 second, Ms. Esquire, if you don't mind me addressing a question in the chat.
Go ahead.
Lovely Dip T, you said it says, assuming that Jane Doe 16 testifies as the government represents. Yes, they're saying if she does, assuming that she will. Listen, the trial's about to start. Some people do back up. That's why she's saying that. That doesn't mean that the person's not testifying. Is that correct, Ms. Esquire?
That is correct. So they have to say, especially from the court's perspective, Judge Donnelly has to say, assuming that she testifies, assuming that she said, because of course we don't know. She may ultimately not testify, right? These rulings are whether or not she would be allowed to testify. That is what Judge Donnelly is deciding.
Exactly. That's it. That's all.
That's it. That's all. She can't control whether or not Jane Doe actually does testify. So you never know. Okay. All righty. So we are now on page 29, but of course we want to run it back probably to 28 just so we are sure of exactly.
She is giving them everything.
All right. So they go into Jane Doe 16 in her testimony. And they do mention that she may not testify here towards the bottom of the page, right? So it's possible that she won't. Then they go in to talk about Jane Doe number 16 and Jane Doe number 17, okay? So let's talk about this little section here, okay? So let's start with here. I'm not saying that. I'm saying even if she does not testify, I think it is still relevant and admissible because Jane Doe number 5 firsthand saw and heard what was going on. And it was relevant. It was one of the ways in which the defendant maintained control over Jane Doe number 5, was showing her what would happen to her if she violated a rule in the same way that she had seen Jane Doe number 16 or Jane Doe number 17 violate that rule. So the court goes on to say, as long as it is non-hearsay, it is admissible. So what is the government wants to present evidence that there was a Jane Doe who broke an alleged rule of R. Kelly's, and that her punishment for breaking that rule was in some way shown to other Jane Does to control them, right? A sort of, if you do what she did, this could happen to you kind of thing.
I think we know who those girls are.
And some of you who are more involved in the sector may, you may in fact be able to make some type of educated guess as to who those girls are. Now, the reason that it is relevant, again, like the judge said, as long as it's not hearsay. So as long as these Jane Does are saying, I saw with my own eyes this or that, it's admissible. And the reason why it is admissible, again, is because it all goes back to the racketeering and the enterprise. Why? Because there is always someone involved. When you have R. Kelly is usually in these allegations, not himself showing girls what happened to other girls, right? R. Kelly is usually not himself doing all of these things and carrying all. It's usually someone he told to do it. So Judge Donnelly is saying all of this is relevant because more than likely, whatever this punishment was, whoever filmed this punishment, whoever observed, whoever, they're all a part of the enterprise.
Right. Being that they were actually in the room recording it, they're complicit to the crime. And they were under direction of him to sit there and record it, aiding and abetting.
Precisely. And so that's the allegation. And so Judge Donnelly is saying that's relevant. That's pretty much her ruling. Okay. So now let's go on to page 30. Okay. So now we have another teaching moment. She then says again, usually a defendant's prior sexual conduct is not relevant, but there is an exception under which it could be relevant. However, that still has to pass through Rule 403. So Judge Donnelly is saying, listen, a lot of these pieces of evidence meet the exception where, yes, we're going to be discussing R. Kelly's past sexual conduct, but it still has to be more probative than it is prejudicial. Still has to meet that standard.
Right.
Okay. Now, towards the end here, again, she clarifies, she says, everything that I ruled to be admissible is because it is direct evidence of the enterprise.
See, direct evidence.
Room for you wondering, well, why is this? She's very clear. Because it is direct evidence.
Direct evidence.
Right. Everything links. The pieces of the puzzle go together.
Everything is connected. And again, make no mistake, all of these allegations are not that R. Kelly, almost all of them say that R. Kelly told someone to do something.
See, that's what they see.
That's the definition of an enterprise.
See?
Right.
They saying he told them to do it.
One person telling someone to do something, they then are in concert committing an illegal activity. Enterprise. Okay?
So in my opinion, I have a question. In your opinion, I meant to say, in your opinion, do you think that throwing a racketeering to get a RICO together for him was a good thing to make something stick?
So here is what I think, in my humble opinion, right?
Yes,
I think that if the prosecution were to try to form a case in which they only talked about his contact with these girls and they did not discuss this alleged enterprise, they would have too many holes in their case. Right? Because they would have a case where they're presenting girls being punished and girls being filmed. And any person with a brain is going to say, well, who filmed? Okay, so who who gave her that cell phone? So how did she get from the concert to his house? So all of these questions are questions that naturally flow. So I think their case would have had way too many holes in it if they did not present the enterprise.
Wow.
Okay.
So
that's why
throwing a RICO charge was a good thing to do to put R. Kelly in jail for abusing the girls.
I think so. I think that it made a stronger case. And what I also think is, and although the government will probably not openly admit this, it sends a stronger message. Because when you have men who are in power, a lot of times they use that power, right? So again, whenever you have like a rapper or a singer or whatever, you guys have heard all these stories, right? We're the video girl days. So we know that LL Cool J doesn't walk up to a girl and say, hi, how are you? We know he sends somebody. We know Trey Songz doesn't walk up to a girl and say, hey, how are you? He sends somebody. So the government is sending a message to all of these powerful men. Watch yourself. Because if you start to send people to do things that are illegal, you're forming an enterprise.
Exactly. Thank you for that.
You're welcome. I'm going to take a quick look at the chat, see if there's anything that, I don't see any questions. I just see a lot of comments. All right. Hello to Nicole. All right. I don't see, and you know, OCOV, I already gave you a shout out. Hi to Rocky.
Shouting out once again, OCOV in the building. What's up, guys?
Hello. How are y'all? Thank you for being so supportive. All right. Let's talk.
Hello, family of Miss Esquire as well that's in the chat.
Oh, absolutely. Absolutely. A lot of my OGs, as I now call them, are here today. Oh, my goodness. My dog is barking. I don't know why. Anyway. Okay, so we're going to have...
check on that if you can. That's fine.
No, he's good. He tends to, he sees a shadow in the window. He barks. So now we're getting into some blue. So for those of you who have just joined us, pink highlights are rulings that were in favor of the government. Blue highlights are rulings that were in favor of the defense team. And then yellow is just something that we should discuss for our own edification. So here, after 30 plus pages of the transcript, we've gotten into something that was ruled in the defense's favor.
Oh, wow. Look at guys, you just got to win. You see? R. Kelly got one little win.
So we're going to take it back. We're going to roll it back to page 33, right? So we can know exactly what we're discussing. Okay, so here we go. Ms. Getty says, the government anticipates that as a part of Jane Doe number 1's examination.
Do y'all need a little break for a second? Because you guys get some moment to stretch. All right. We are listening to Empowered Esquire. Y'all, don't get discouraged. I'm telling you, don't get discouraged. It's all... Don't get discouraged, okay? Do not get discouraged. Okay, here we go.
We would also elicit the allegation or the fact that he admits that in 2008 he had access to a juror, and the defendant's response to that, the thing we are far more interested in introducing, the fact of the 2002 charge and that the defendant was on trial for was under indictment for such a long period of time and was ultimately acquitted in 2008. The court then says, what's the relevance of that? I'm not inclined to permit it, by the way. She then goes on to say, I don't see an admissible purpose for that. Generally, the fact that someone was acquitted of a crime, you would not be permitted to inquire into that. And I don't really see a good reason to permit it here. Obviously, if something comes out during the trial, that, again, doors can be opened all the time. But I don't think that's admissible, so I'm not going to permit that.
Okay, break that down for us, girl.
All right. So here is what just happened. So here the prosecution said, Judge, he was previously acquitted, and there were murmurs that the jurors were tampered with. So we want to be able to discuss that trial. And the judge said, no, when you are acquitted of a crime, it's not fair for your acquittal to be brought up when you're being accused of a totally different crime. No, that's not admissible. But at the very end there, she says, doors can be opened all the time.
Right.
In the legal world, whenever a judge says, well, if someone opens the door, this is what they mean. If someone on the defense end, whether that be R. Kelly or one of his witnesses or one of his attorneys, mentions that previous trial or alludes to that previous trial, they have opened the door. So that's what Judge Donnelly means. So she's saying, prosecution, you can't bring that up. But if they open the door, you're more than welcome to walk through.
They're gonna kick in the door like Biggie. It's the Brooklyn way.
So that's what that means. All right. So, I mean, any thoughts on that, people? Let me actually go back up to it.
That's crazy. So she can just like she said, we're gonna leave that out. That's not importance. But if need be, something creaks open and leaks in, we gotta throw that in.
No, she didn't say that. That's not what she's saying. She didn't say you got to throw it in.
Brings it up in any way, then you're welcome to talk about it, but you can't bring it up.
Got it.
They can't bring it up.
Okay.
So the government can, but the government can't. The prosecution can't, but the defense can.
Yes, and if the defense does, now they've opened the door for the prosecution. So
she didn't highlight something.
If you were found not guilty of something, the government should not be allowed to talk about something that you were found not guilty of. You were acquitted, right?
She didn't even put in. She didn't even talk about. She didn't highlight the next thing. She's being biased, y'all.
And I got acquitted. Well,
she didn't highlight the next thing about the pornography.
Right. Okay.
That's what he's saying. Does that make sense?
Yes, ma'am. It sure does. You got that, guys?
Everyone in the chat got that?
We got some slow bus people in the background, though. They way in the back.
All right, so now we're still on page 34 still, and now we're down towards
she didn't even read one of them. She didn't read one of them.
The court saying the next category of evidence has to do with audio recordings that depict the defendant yelling and physically assaulting women. And those are clearly admissible as direct evidence of the methods used to perpetuate the enterprise. And it is direct evidence of the defendant participating.
Okay, so that evidence where he recorded cursing the girls out and threatening to abuse them will be admissible.
Precisely. And the judge is saying it is admissible because it proves that he was involved in the enterprise, and it proves that there was an enterprise because the enterprise had methods by which it punished people. So going back to what Diva said about the mafia and gangs and things like that, when you do something wrong in the mafia, there's a punishment, right? They take a finger, they take a toe, they bust your kneecaps, whatever. So every enterprise has punishments for when you break a rule. So that is why it's relevant. Because Judge Donnelly is saying, well, this tends to show that there was an enterprise and these girls were being punished for breaking one of the enterprise rules.
Auntie, you go, Auntie.
Listen, Judge Donnelly is on it. She's on it, and I think she's fair. All right. So now we are going all the way to page 39. Now, this is in regards to some text messages. So Judge Donnelly was talking about some of the text messages that were exchanged allegedly between R. Kelly and some of the Jane Does. And she says specifically, it is not hearsay. If she says she wrote it and what the reason was, it is really not hearsay. It's evidence of fact. So that's her ruling regarding all these text messages. If they can get someone, any of these Jane Does, to say, yes, that is me, yes, I sent that text, then Judge Donnelly will decide that it's admissible, that it's not hearsay. But it will be hearsay if they're trying to enter it in through some other witness.
Okay, so because there was also text messages between the employees, and there was text messages between one of the Jane Does and her parent.
Right,
So
right.
Which ones
Yes,
are those?
also may be admissible. And again, that's another thing that the defense may ask for a curative instruction on, right? So Mr. Farinella may say, okay, Judge Donnelly, we know that you're letting in these text messages. We would like you to explain to the jury that these messages are not necessarily to prove that something happened. They're more so to prove that there was an enterprise. And so Judge
This
Donnelly,
is like,
and this is an example, by the way.
So she's letting that in too. She's letting that in too.
she didn't say that.
I'm just
She
giving
did
an
not say
example
that.
of what Mr. Farinella
She did not
could
say
ask
that.
for.
Mhm.
Oh,
And
okay.
then Judge Donnelly's instruction could be, ladies and gentlemen of the jury, the text messages that you just heard about testimony in regards to, you are not to consider that testimony for whether what was discussed actually happened. You are to only consider that testimony to establish that there was a concerted effort and communication going on between these parties.
Okay. So they have to prove that the conversation really happened.
Right. They have to have someone who can authenticate that conversation. Because I think we discussed this on your channel before when we talked about text messages. So
Yes.
people who have never been to Diva's channel, let me break it down for you really quickly. When you have a text going from one cell phone to another, any defense attorney worth $1 knows that the best argument to make is, yes, that text came from my client's phone, but he didn't send it. Or yes, that call came from my client's phone, but she didn't make that call. So that is why you have to have a witness to authenticate. Because just because a message was sent from one person's phone to another person's phone is not going to stand up in court for you to say that that message definitely came from that person. Someone can always take your phone and start sending messages.
Okay, yeah, got it.
So that's all Judge Donnelly is saying. She's saying, give me the person who actually sent these messages, have her say she sent them, and then you're welcome to talk about them. That's it.
Okay.
All right, so I think we, I thought we were rounding it out, but we got a little bit more. Let's see. All right, so page 46 here.
I see she didn't highlight the stuff that the judge gave him.
Donnelly is about to discuss whether or not the defense can go into the mental health and the mental history of these Jane Does.
Okay.
There has been a lot of hubbub about which Jane Doe has depression, which Jane Doe is bipolar,
Right.
which Jane Doe has a therapist, all this other stuff. So Judge Donnelly says this. With respect to one of the witnesses, I think it would be decidedly unhelpful to the defense just as a practical matter given the nature of that evidence. So unless there's a showing that a witness's mental health affects the witness's ability to perceive and recall, that evidence is inadmissible.
Okay. I'm sorry.
Oh, no, you're fine. Did you have a statement to make before I break it down?
Yeah, so in other words, they can't talk about that. That's not relevant to the case because
Precisely.
her trauma is her trauma.
Precisely. Right. So in general, they cannot talk about, like I said, which Jane Doe is bipolar allegedly, which Jane Doe is allegedly, depressed. They cannot talk about that in general unless they can prove that. So that's what she means by a showing, right? Unless they can prove that whatever this mental health issue is, it's affecting the memory of that witness. And so they're not reliable.
The memory.
Only they're be able to get that in.
So do you think that in this trial they will have health professionals testify about these girls' mental health issues, or they're saying they're not going to let it in at all?
So what Judge Donnelly is saying is it can only be let in, like I said, if there is a showing that it is affecting their memory. It's affecting their ability to actually recollect what happened.
I want to remember what happened. Okay, got it.
So the defense team may present the defense team may try to present some sort of professional, that's showing, right? So let's say, for example, being allegedly bipolar. Maybe defense counsel has some expert that they want to present who says that, when bipolar people are in mania, they don't remember what they did.
Right. They block it out.
Right. Now you're taking a step towards opening that door if they can prove that this Jane Doe is allegedly bipolar.
Yeah, and I was talking about that the other day on my channel as well, that, a lot of victims of some type of
she's not
assault,
she's showing what the judge is letting in, so we should know what the judge is allowing.
So when we show up on trial or we're going to the police about things, we don't all remember.
We should know what they're allowing, because you don't want to go in there blindsided.
Look like the time, it's when you're shooken up, you're shooken up. It's hard for a woman to stand on trial and remember every little incident. And then with the attorneys,
she's allowing these things in.
It brings it to a very bad place. I feel bad for these girls. That's all I gotta say.
So I'm gonna hop back in the chat and say hello to some people, and address a few comments. So we have a lawyer-minded person in the chat.
Okay.
Who is alleging that they are a supporter of R. Kelly and they are arguing about parents being charged. Be careful what you're doing. You are hurting R. Kelly. I'm going to say it one more time. If you are saying that you are an R. Kelly supporter and you are arguing about parents being charged, you are hurting R. Kelly. You are not helping him, because you are saying, yes, these girls were abused. That's what you're saying. You're saying, well, the parents should be charged too. Yeah, he did it. So charge the parents too. You are saying R. Kelly is. Do you realize that? You're saying.
No, they really don't.
So if you're an R. Kelly supporter, be careful what you're saying online about the parents and everybody else involved, because you could be confirming the allegations because you're worried about someone who's not on trial right now. This is the trial of R. Kelly. Let's focus, people. Let's lock it in. Okay.
Right.
Well, here's what Judge Donnelly said about the parents. Unless the witness participated in it, then, certainly cross-examine them about that. But just a general question about what the parents were doing, in a case with allegations like this, and the parents couldn't consent to the behavior that's alleged, so it's not really relevant. Pause. If a person is not of the legal age of consent to have intimacy, no one can consent for them. So if someone is only 14 years old and some person wants to have contact with them, their mom or dad can't say, here you go, you can do it, and now it's okay. That's not how it works. It's illegal. Right?
No, she's wrong about that, y'all, because I just read in North Carolina. Hold on.
She's saying
she's wrong. She's wrong, because I just read in North Carolina that that's the state that the parents allow them to marry a child. So she's absolutely wrong on that one, y'all. She's absolutely wrong. Because I just read to you earlier this morning. Early this morning about that. I'm gonna write her and tell her she absolutely is wrong about that, because the law in North Carolina is they trying to change the age up to 16, because right now it's the age of 14. If the parents give permission, yes, you can have a relationship, you can marry them. So she's absolutely wrong on that one. I'm gonna write her. I'm gonna send her that whole thing too, because she's wrong. Absolutely wrong. Yep, Nova, yep. I got it right here. North Carolina. I read it to you guys this morning. She's absolutely wrong. Oh, I'm going to write to her on that one. Oh, I'm going to say, yep, you're absolutely wrong. Oh my God, I got to sneeze. Hold on, y'all. I'm Gary. I'm going to email her and tell her, hey, you are absolutely wrong about what you just said, because I just read it in the state of North Carolina. Hold on, y'all. She is absolutely wrong. I'm going to send her the law, too. All the southern states have that law where the parents can sign consent. Yes, they can. Sure can. Surely can. She is absolutely wrong in that one. What you say? You can't hear? We can't hear? You can't hear? You can't hear what's going on in the you can't hear it? I turned it off. Hold on a second. I'm just gonna tell her, hey, the what section? I gotta tell her on her. Where's she at? Where's she at? She's on 12019. I gotta tell her she's absolutely wrong on 12019. Hold on. I gotta tell her. Sorry. Law is different from state to state. You're wrong. Yep. Like I said, state to state is different. Thank you. It's North Carolina 16. Yep. State to state. There. Yep. Every state is different. She's saying that she went around blanket. I thought, yep, you're absolutely right. She said, messy oops, state to state. The defense has to counter these allegations and fiercely cross-examine these witnesses and use their own admission, even on social media, against them. They have to concentrate on combating their lies. Yep. Yeah. Hold on a second. Let me get her thing. Okay, I'll go back. Gotta go back. Sorry. I know you guys. I know you get upset because of what she's saying, y'all. But we need to know this stuff. We can't walk in there blindly and not understanding or hearing what is being said and what the judge is accepting. We gotta be educated, y'all. We gotta be educated. You get what I'm saying? We gotta be educated in what this judge is allowing in there, because we didn't know that she was allowing all this stuff in here. We gotta be educated. We can't just get upset about it. We gotta know what we gotta pray about too. You know what I'm saying? Sometimes gotta know what you gotta pray about. All right, so
because regardless of what you're alleging the parents did, the parents can't give you consent to have a legal contact with their child.
Yes, you can. Yes, they can. She's wrong right there.
No, the best part is when R. Kelly has the Gayle King interview, and he says, "But the parents sold them to me."
Oh my goodness. No comment. Judge Donnelly then goes on to say, so that's not going to be admissible. Just generally talking about the parents. But if the allegation, which is what I understand it to be, is that the particular Jane Doe witnesses were a part of this plan, then you can ask them about that.
See?
So here's what she said.
She said you can't ask
If your allegation is that the parents were a part of the enterprise, you can ask them about that. But then again, remember my initial comment, that's a trap. That's a trap. Because if you're questioning the parents about them being a part of the enterprise, you're admitting there's an enterprise.
Whatever.
So that doesn't even make any sense, okay? But anyway, she said that's not admissible. She said absolutely not. That was her ruling on that.
Okay. So
And,
no, I'm not talking about the parents.
Yeah, I think
unless they were part of the enterprise.
Right. And so we are actually at the end of that transcript. So listen, I'm going to have Diva.
Wow.
Okay, that was the end of that. That's why we need to transcript ourselves so we can read the whole thing, because they highlighted what they wanted to highlight and they didn't highlight the stuff that we want to see. They didn't put the part that because I saw something in there that she ruled for the defense, but they didn't read that one. That's why I'd rather have it ourselves. Yeah, that's what I wanted to read. I wanted to read those things in there. See, they got to prove this in the enterprise. They haven't proved that. She's just admitted, and she's allowing them to do the test. It hasn't been tested yet, so. Oh, she is. She always has been. Divine Diva, yes, she is. She definitely is against R. Kelly. She definitely is. She's from over there, Oak Cove, remember? She's definitely against R. Kelly. But you know what, y'all? Let me explain something to you. It's the people that's the thing we got to look at. You got to look at this. It's the people that was inside that work with him. No matter how we kind of sugarcoat it and bring the government about it, it's those people who brought the government involved in it. It's the people that work for him. It's that's what we got to look at. Forget the government. Forget them. Who brought this upon them? The people that actually work for Robert. They haven't even filed the paperwork yet, y'all. His team hasn't. It's 11:04. They haven't responded. What is going on with them? This is the kind of stuff that makes me mad. They were supposed to respond by today. It's almost 12 o'clock. Why do they always wait to the last minute to respond? Farinella is supposed to respond. Why do you wait to the last minute to respond? That's just like one of those kids who have deadlines. When his deadline is supposed to be at 12 o'clock today, before 12 o'clock, and it's 11:04, they still have not responded. The judge gave them additional time to respond to those motions. Because they asked for motion to dismiss. Please show us the federal law about parental consent for minors. I didn't see it. I didn't see it the other day. Oh, you talking about earlier today? We did it earlier today. That was earlier today. Each state has different law, but North Carolina, there's 14. Alaska's 14. Ooh. Okay, parental consent on Arkansas is 17 for boys and 16 for girls. Delaware, okay, let me let you guys see it. Wow, Massachusetts is 12. Ooh, hoo-hoo. Hold on, let me show y'all. Hold on. Massachusetts is 12. Ooh, Lord have mercy. Oh, Spitfire, I didn't see you in here. Hold on. Ooh, Lord, Massachusetts is 12. Hold on, let me make the show y'all the link. I mean the site. All right, this is the state. According to the states. Hey, lady.
Hey, what's going on?
Nada, how you
I
doing?
just came in. Came in. I said, why is the chat so dark? I was finna go back and listen to your interview. You did an interview with somebody or something? It's
No, no,
bright.
no, 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 no. No, I was playing somebody else's content.
Oh, okay. What I miss? I'm sorry. I just came in. I wasn't even in the bushes. I'm sorry, y'all.
No. um, this person did the transcript from the 3rd of August. And in the transcript, she was highlighting some stuff that the judge is allowing. And so we were going over and some things she mentioned something about.
Well, we already knew what the judge allowed. Allowed in.
Allowed everything.
Well,
Like
we said
everything.
that back. That was 2 weeks ago, wasn't it?
On the 3rd, yeah.
But didn't the defense come back after that and ask for some stuff to be dismissed?
Yeah, but they haven't. Then the government opposed it, and they're supposed to have until 12 o'clock to debunk what the government opposed, and they haven't done that. They have 12 till 12 o'clock.
Oh.
They haven't done that yet. Okay. Somebody was asking me. Oops was asking me. There it is. Oops. With parental consent. 12 in Massachusetts. California and Mississippi don't have a minimum with parents' consent.
What
There's no
parents
minimum.
consent to what?
Marriage to somebody older.
Oh. Okay. I'm sorry, y'all. I've been up. I'm tired. I don't know what. Well, here's the thing. Here is the thing.
But the state, okay, she said, I thought he was charged federally, but this, okay, hold on a second. Let me get this the federal because state is each one. So let me get the federal. But the state governs what the federal is in that particular state. The federal still has to abide by what the state law is. Sorry, Miss. Sorry, I'm back.
Well, I don't know what's going on. I'm listening.
No,
I may should just go back and
no. Messy Oops had asked what was the but that's why they have to go by each state. Sorry. Go ahead, Spinfire.
Okay. Well, I don't know what's going on. I just was
No, because Messy Oops asked me
right. I
about
said she thought that the federal age wouldn't matter since it's a federal charge.
no, but they gotta go by what each state. Just like you know how they took it to New York because New York is 18. They could have kept it in this
And
the
then not
other
only that,
state.
New York just changed some recent laws and stuff like that. That's why they want to, because they figure they can probably get a conviction for sure in New York.
Yeah, they're going by what state they think they're gonna do it best in.
Right. And then because they know that if he gets some convictions in New York, once they convict you, then some other ones go find some convictions and all that kind of stuff. So that's what they do, just like they did Weinstein or whatever,
Yeah, yeah.
or whatever. So you said you was listening to somebody else, but why you shout out who's the Empire? Esquire?
No, I use her stuff. That's why I shout her out. Because I don't
Oh.
want her to you know how some people be like mean and wanna hit your channel if you don't. What shoes?
Oh, so you didn't interview some you just
No. She was just I didn't interview her.
Oh, okay. Oh, okay. Okay.
You
Well,
going outside?
I said the chat seems so depressed. You could feel it through this computer. What's going on? I looked, then I went back up the chat and they was like, "This don't look good." Wow. I'm like, what the hell going on? So then I was finna go back and read. I was like, I don't hear nobody talking.
No. Stuff that she
I
was
was all over
saying.
the place, honey.
No, she was saying some stuff that was in the hearing. What the judge went line by line of each one and what she was gonna allow admissible and what she was not gonna allow.
Okay.
So she allowed a lot of things.
Right,
Huh?
we knew that when we read it.
Yeah, we didn't read that.
Oh, okay.
The actual transcript had to do with the transcript from the hearing itself. We didn't have that.
Oh, okay. Okay. And so on the third, she allowed a lot of stuff in. Okay. Well, I'm quite sure she's gonna probably allow stuff in, and then the defense gonna probably put in motions to try to get it dismissed, bagging with some law or whatever. I doubt if she probably do it or whatever, but that's normally how I do because of all these claims.
Yeah, but they explained that where the enterprise come in is that if he's instructing those people to do those things, that's considered enterprise.
Well, we knew that. We said that before. We all said that on our platforms before.
No, but I'm just saying that because they were basically
If you like, say for instance, if you sitting up there, you like a girl or something like that, and you send somebody to go get her or stuff like that, they're using that as an enterprise. They're using his entourage as an enterprise. We all been saying that for the last 2 years. That ain't nothing new. I think everybody is just hearing it again and seeing it in the transcript and stuff, got everybody riled up. Because we said that and broke that down even when they was reading indictments before they even got to the motions.
Yeah.
We already been saying that stuff. Like if I'm a rock star and I'm sending people to go pick up girls or introducing the girls or whatever, that's considered an enterprise and stuff like that or whatever. I don't understand that because that would be just like if I like a guy and I say, Sylvia, go over there and talk to that guy, tell him I like him. You know what I mean? Or whatever. That's no big deal, but that wouldn't be considered an enterprise. I mean,
Yeah, I'm saying that considered enterprise.
yeah, they said they're gonna say that because he's a powerful
Instructing them to
person,
do it.
right?
Yeah,
And they're using that because he's a celebrity and
yeah.
stuff and
Because they saying he wouldn't go there and do it himself.
right. You know what I mean? Or whatnot. But that's why they wouldn't go there and do it themselves at the same time. So it's really like a catch-22. You go in there, do something yourself, then this damn harassment and all that kind of stuff. And you know what I mean? So you want to feel the vibe or whatever. But it goes back to accountability. Like, I don't give a damn who you send at me. It's up to the person to say yes or no. I mean, people don't think like that no more. And the court's not thinking that way now because of the Me Too. And time's up. You know what I mean?
Yeah.
You know, everything have to be proven or whatever, but she's gonna let a lot of stuff in because I kind of figured she was gonna let a lot of stuff in.
Independent thinker. I wasn't saying it happened in North Carolina. Not, no, I did not say that. Listen to what I said. She made a comment that you cannot say anything about the parents because the parents cannot give permission. And I was saying that in North Carolina, a lot of the southern states give permission for their kids to have consent in marriage. That's what I said. Guys, y'all got to learn to listen. Listen to what I said. I never said it happened in North Carolina. We're using that as an example. Oh my God, people have selective listening. Lord have mercy.
You got to say things real clear because the comprehension level on these streets is, ooh, girl, I'm trying to tell
Oh my
you.
God. I was just using an example because she made a statement saying a parent cannot give permission for a child. And I was saying that in North Carolina, they have laws where the parents can't consent for the child to get married, child brides.
Yeah,
That's
they
what I was
do.
talking
They have
about.
that. They've been had that.
Oh my goodness, people.
They've been
Not once did I say that any charge was in North Carolina. Not once did I say that. Jesus. Cheese and crackers.
Cheese and
Oh,
crackers.
cheese and crackers.
Oh Lord.
Why do people do that and come in and half listen to something and then put it into something else? No, I did never. I never said that the charge was in North Carolina. Never did I say that. Oh my God, people, listening and comprehension, please.
But see, what people fail to realize is this. Okay, you are a plaintiff. You and there's a defendant. So if I say I got this, that, this, and he did all these things to me 9 times out of 10, the judge and the court's going to want to hear everything that the plaintiff have to see if that burden is where I lie.
Yeah.
And the proof of that has to be with me. So if I have the proof and the proof is with me, and I'm saying this is my proof, a lot of times the judge is going to let it in. Okay? A lot of times the judge is going to let it in. All right? It doesn't mean anything because the burden of proof is still on what we call the government and or plaintiff or whatever. Because they have to prove that because they're the ones bringing about these charges, right?
Mm-hmm.
Right. But then we have the defense that say, okay, we want to challenge certain witnesses and things like that. And the judge may say, okay, yes, or may no. Okay, because it's still it's probably still their proof. Their proof doesn't mean it's going to be it's going to hold up. It just means it's their proof, right?
Mm-hmm. Mm-hmm.
Right. But then once we get the proceeding starts and we get cross-examined, and then we start digging into things, what we're going to do as the defense is what they're going to do is discredit their proof. That's basically what a defense is to knock down, strike out, and discredit. The burden is not on the defense; it's on the
Just
government.
the government, yeah.
So all of what the government says that they have, if these are their proofs, the judge 9 times out of 10 going to let it in unless it really has no bearing on it. You know what I mean? Unless it really has no bearing on it, they're going to let it in. Because if I'm making a complaint like this, like you, if you and I got into a spat, you're the plaintiff, I am the defendant, and you got to prove that what you say I did. You got to prove this. So you say I got A, B, C, D, E, F, G, H, I, J, K, right? So you got A through J, and you say, Judge, this is my proof. And then I said, Judge, well, she shouldn't be able to use those proofs because of this. The judge said, no, she can use them because this is her proof. Like, rightfully so, you can bring about a charge on somebody in court, and you can say, this is your proof. Now, will it hold up is a whole nother thing.
Yeah.
So then once you present your proof, I can say, well, yeah, she got A through K, but I can debunk A through F, and then G through K, I can strike them all down to where they minimum or nothing. So the judge can be like, okay, well, your proof really didn't hold up. You see what I'm saying? Because it's not, it has no merit here. You know what I mean? But the court's gonna want to hear. The jury's gonna want to hear. You know what I mean? Because that's how we do it here in our law. In our democracy, it's made up like that. It's made up of the plaintiffs making charges. The juror has to hear what all of what these complaints are, and their witnesses. As a defense, he can strike those witnesses. He can bring up some things with those witnesses. He's supposed to bring up some things with those witnesses. And then if they open up the door, because they're going to ask questions to open up doors. So what was striked out, and then when you cross-examine somebody, say some things, then they go cross-examine with judge, they brought it up. And then the judge said, okay, well, now it's added in. And that's how it normally goes in court. You know what I mean? That's how it normally goes. That's how it normally goes. You know what I'm saying? So, or whatever. It goes that way. But you got to understand, everybody, like a lot of lawyers and female lawyers and things, they are against R. Kelly. We are the oddball.
Yeah.
People don't understand that. We are the oddball. That's why I've always said, even if the other night when I was on your channel, I said, if he get convicted, I'm still going to advocate for him because I know it was injustice. Because the Me Too era, this is the Me Too era. But what happened in injustice? We have what's called appeals. We have what's called, and one thing I've always told you that I told my co-host is that we have something called the Supreme Court. When you get to that level, they're not going to let no organization run.
Yeah.
They're not going to let it run. There's no room for Me Too and stuff like that. And these judges who allow certain things, in Bill Cosby case, what did they do? They said, why did that judge allow that in? They didn't understand why that judge allowed these things in.
Because a lot of them are biased.
And in the courts, and see, these are different justices made up of men, women, in particular age, and they're going to go by the law. Period. Not by feelings, not by emotion. They're going to go by the law. And we got a court, we got an appeal process and stuff. So, you know, and that's just the worst case. That's all I'm saying. That's just the worst case. But it is what it is. And we gotta make sure that we continue, regardless of what the outcome is advocating. If not more than ever. If not more than ever. You know what I'm saying? So because the worst case that, you know, this is crazy. But don't put, what I try not to do is put negative energy out there. If somebody's saying something negative, you may not want to put it on your channel and feed.
It wasn't negative. It was more of learning of what the judge said yes or no to. I don't think that's negative.
Oh, okay.
So it's facts. It's what this the transcript.
Oh, okay. Well, I didn't hear
It's
it.
just the way
I
people
just
feeling
thought that it
about
was
it, for
somebody was
what the judge
interviewing
is
somebody and
allowing.
they were just saying something, huh?
It's what the people feeling because the judge is allowing it. That's what it
Oh,
is. I
okay.
mean,
So
there,
she was just reading what the judge said that she was going to allow in and what's not, and she was
yeah.
saying what it was. Okay. See, I didn't know that. I just thought it was somebody interviewing somebody.
No, it's no interviews to her reading the actual transcript.
Oh, okay. Okay.
It's nobody interviewing anybody. It's just what. But people just, we know we're upset about what she's allowing.
Oh, okay. Well, I'm quite sure that that's probably, the way that is going to be, because if we bring about a charge, we want our evidence brought in. You know what I mean?
She said the thing is, my thing is, if they feel violated, why take a settlement instead of going to authorities? So take the money. Now you broke and you want to come back and say something. You're right.
Absolutely. And see, that's the thing. And that there is one of the reasons why I spoke on Bill and his stuff was overturned, because I did one yesterday with these NDAs. You know what I mean? I did one yesterday with these NDAs. And these NDAs, they're law abiding. And these small courts are not trying to honor that as a law binding contract, when it comes to this Me Too time's up. But these higher courts are going to make that stick, because you can't do that. You can't do that, because if that's the case, nobody would ever sign NDAs. If that was the case, nobody would sit up there and say, okay, well, I'm not gonna do it. Nobody's just gonna do that. You know what I'm saying? So,
Mhm.
we don't know. You know what I'm saying? We don't know what the outcome of this trial going to be. We don't know. Just because she let it in don't mean anything. We don't know. But when I came in your chat, it wasn't uplifting as it normally be. I felt it. So I was like, what's the hell going on?
No, it's just a hard topic. It's a hard topic. It's not pleasant.
No, it's not. It's not. It's not.
Especially when you hear that she didn't let, like, because all we heard was the stuff that she didn't let in. We didn't hear the stuff that she let in. So it was so many things that she let in. I'm like, oh, I didn't know that she let this in. She didn't let that in. Because when they came back from court, we only heard the three things that she let in.
Well, shit, look at Deronda Pace. They let her shit in.
Yeah.
Think about that though. They
Yeah,
let all of her shit in.
they did you know they let Aaliyah's thing in?
Yeah, well, yeah, because they say that they got
Direct witness.
yeah. They saying they got a direct witness that was like into all of that. So they saying they got a direct witness. Who you think that direct witness is?
Demetrius and Azriel. They said number 5.
Mm-hmm.
I'm still waiting for this. I just checked a few minutes ago and nothing came up. For you, it says 16 for MA. Where's MA? Nova, where's MA? Where's MA?
Did they say something about the parents?
Yeah.
What did they say about the parents?
They're saying that it's not admissible to question them unless there's something that comes up. But listen to this. The lady is saying that you could tell she's one of them over there, even though she tried to act like she's neutral, but I doubt she's neutral. What lady's battling cancer? I haven't talked to tech guy. Will Aaliyah mother testify? Oh, she's battling with cancer? I didn't know she was battling. Did you know that?
No, I didn't.
Wow.
No, I did not know that.
Like we sit here and we wait for this thing to come in. I hope it don't come in 1 o'clock like they did last time. And we wait. She will not allow these prosecutors to tarnish her daughter's legacy to benefit Me Too and Time's Up. I won't be. I would bet she's on defense list.
Well, I am so. Oh, Lordy. I'm
Huh?
glad I didn't listen to. I don't want to listen. I don't want to go back and listen now. I don't want to go back and listen. It don't need for me to go back and listen. But yeah, it ain't over till it's over, you guys.
You know the other team, the other side is in here, right? You see the numbers up in here?
No, I don't. Let me see. I haven't seen the numbers. I haven't even seen it. So who is this channel? Oh, you got 212.
It was more than that earlier.
Oh, okay. Okay. I haven't seen it. I haven't even heard it and or whatever. What channel was this on?
It's called Empowered Esquire
Oh, yeah,
TV.
you got it in your thing. Okay. Okay. Let me see. Let me look it up now. Esquire TV. Let's see. Ooh. Okay. Okay. So she. Oh, okay. I see. So she got a live chat. Let's see who's in here.
Huh?
Oh, it ain't number Oko. She Oko.
She claims she's not, but she got Oko because Diva was her guest.
Who people who are
No,
saying something and favoring to what somebody believes.
no, Diva was her guest. You see what
Oh,
I'm
okay.
saying? Diva was her guest, and she brought all her people over there with her.
Oh, okay. Okay.
But she's been around but she claims she's neutral.
Oh, okay. Okay. Well, hmm, well, you gotta have the good and the bad, the pros and the cons. That's just how it's gonna be. It is what it is. Until we run out of all options in our court system, it is what it is. I'm not going to nothing that we can say about it.
Hey, chess player.
Oh,
Have the judge rule yet? No, they have to wait for the defense to put in their motion.
they probably. Oh yeah. Hopefully you don't put that under that seal shit.
Michelle says she subscribed and unsubscribed. Michelle, I'm about to do the same thing too.
What? Subscribe and unsubscribe to what?
I thought she was neutral, but I'm gonna do the same thing that they did. Unsubscribe. Woo, Michelle, you too much.
Oh Lord.
Michelle, trust me. I look. I had to keep it quiet.
Oh. Well, look, I just was anxious to see because I seen that you was live and trying to figure out what was going on. Obviously, I'm in the darker stuff, so let me get my butt on out of here and
You
just do what
leaving us again?
I was planning on doing. I just came in because when I just was in the chat, I was just coming in because I got my notification. You know, you don't get your notification right when you go on. It depends on when they want to let you know somebody was on. So I had just got my notification, so I came to see what you was doing. I seen the chat, and then you have to explain, and I don't really know what's going on, so I really don't have no conversation for it because I have no knowledge of what's going on.
Oh, gotcha.
So, oh well, don't worry about it, you guys. Y'all be all right. I'll talk to you later.
I'm waiting for the thing to come in, to pop in.
Okay, hopefully, text me or something when you do.
Okay.
All right, fire out.
All right, bye. Yeah. Oh my God, it's still not in. Yeah, it's 11:35. We're waiting on the midnight hour. Current council report is rumor she is better. You all, Ms. Halton stated in an interview between 9 that she's not here for surviving R. Kelly. Tyron Halton is refuting statement made by former. Oh. Trust and believe regardless what happened. Kills that been that nigga since 90s and through 100. Got the whole group of supporters rocking for him. Queen doesn't look like the defense has any else to add it. I'm looking, Queen. Nothing. It says defense must reply, if any, by August 16th. Today's August 16th, and they didn't reply. Hold on a second, y'all. No, they haven't replied yet, Nikki. Yeah, Devin.
This is the message from Peter to Robert, from Nigeria to America, yeah. I'm calling on for. Stay in the faith that your mama left you in with Christ. I'm calling on for. My brother, even though you were thinking you were losing it all, I'm calling on for. You might not even know that your Father in heaven is here. I'm calling on for. Remember, you said me. When you took a look around your life, you said me. How he took you from that utter cry. On your knees in your pool of blood. How he showered down on you with jab. How he healed you of cancer. How he blessed your family with kiss. How he made your mountain pick up high. This is the message from Peter to Robert, from Nigeria to America, yeah. I'm calling on for. Stay in the faith that your mama left you in with Christ. I'm calling on for. My brother, even though you were thinking you were losing it all, I'm calling on for. You might not even know that your Father in heaven is here. I'm calling on for. Remember, when you never knew him all your life. You only go to church on Easter Day. Even though he took your mom, you know. You were not the only one out there. Many died, but you live today. You touched the lives of all the stars and times. Wrote them songs, producing for them. Giving life to helpless children. Helping you to lift up Africa. This is the message from Peter to Robert, from Nigeria to America, yeah. I'm calling on for. Stay in the faith that your mama left you in with Christ. I'm calling on for. My brother, even though you were thinking you were losing it all, I'm calling on for. You might not even know that your Father in heaven is here. I'm calling on for. Remember, if you see them in their darkness, do not fret yourself to look at them. Even if they appear the riches, you are greater than they are, you know. Even if they offer you money, even if they offer you that fame, even if they offer you position, even if they offer you the greatest deal, they may not give you Grammy, but you know your friends believe in you. You don't need no bad society. You're strong because he's there for you. Jesus Christ is watching you every day, and I think he's proud of you right now. This is the message from Peter to Robert, from Nigeria to America, yeah. I'm calling on for. Stay in the faith that your mama left you in with Christ. I'm calling on for. My brother, even though you were thinking you were losing it all, I'm calling on for. You might not even know that your Father in heaven is here. I'm calling on for. Don't you giving, don't you giving, don't you giving, don't you giving to them now. I believe you can fly. The storm is over. I'm calling on for. Don't you giving, don't you giving, don't you giving to them now. I'm calling on for. The Father has it all. He loves you. Stay in. I'm calling on for. Remember.
Okay, y'all, we're gonna wait till, let's see if it came through. Something came through yet. Hold on. Hold on, y'all.
For Robert, Sylvester Galley, I can see you walking out through that open door. This is for Robert, Sylvester Crowley. Make your way and get out to the place where you belong. It's like you, the tunnel and sea. For the wicked people, do 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 America, free Macaulay, son of the Most High, standing up for Robert Kelly. Africans stand up for Kelly.
Dom, I'll do that. Just waiting. Just keep looking.
Free Macaulay, standing up for Robert Kelly. Africans stand up for Kelly. Everybody, Jerusalem, stand up for Kelly. We are free Macaulay. For Robert, Sylvester Kelly. God has heard your cry and has come to change it all. It's not been easy from your beginning. From your foundation, God is gonna walk it all right. Hey, you liars, well, Lord, you Kelly. To the betrayers, they're do 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 yo. Do do do, hey. Do do do, hey. Do do do, hey. America.
Charlotte, you funny. Not singing it.
Free Macaulay, son of the Most High.
Tanya, they said Demetrius gonna be direct witness. But also he said, because supposedly Robert talked to her about Aaliyah. But that's not direct witness, because she was not there. I don't get that.
Standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Everybody, free Macaulay. Freedom for Kelly.
Okay, 4 minutes to it, y'all. Still no reply.
Free Kelly, son of the Most High. America.
Yeah, it comes to Paces immediately. As soon as they put it in, it comes in here. I'm waiting, Dom. Look at us. We're patiently waiting.
Son of the Most High. Standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Free Kelly. Standing up for Robert Kelly. Africans stand up for Kelly. Jerusalem stand up for Kelly. Free Kelly. Standing up for Robert Kelly. Africans, stand up for Cali. Jerusalem, stand up for Cali. Free Mount Cali, son of the Most High. Why are you here? Set him free, oh. He's my brother. He's a good man. We all love him in Africa. He's touched millions of lives. Robert Sylvester Kelly, congratulations. You're out. You're out, man. Thank you, Jesus.
They reply, y'all. They replied. They replied. Dom, I just sent it to you. Dom, I just sent it. Are you still in here? I just sent it to you, Dom. Lord, this is like nail biting thing here. Hey,
Yo, man, finally they took forever.
at the last minute.
The last minute. I knew
And
they
then-
would. I knew they would. They always wait till 12 o'clock.
Oh my God.
They tripping. I knew they
Oh
would
my
though.
God.
I knew they would. They just take their time though. You know, they want to make sure everything is good. Which is understandable. You
Yeah,
know?
but they still had misspelled words on the last one.
Right. I don't understand that either because all you gotta do is hit the spell check and it'll come, it'll review it. So yeah, so this one is, I'm looking at it, it's 8 pages.
What time was it submitted? At
12.
11:59?
Right. Well, it's 12, really.
No, it was 11:59 when I got it.
Oh,
I
okay.
just said send it out to you then. It was 11:59.
Okay. Okay. All right. So, can you guys hear me okay?
Yeah.
Okay.
Hold
So
on a
this
second.
is, okay. Yeah. Let me know when.
I was trying to pull it up.
Sylvia, you got to get the likes up. Y'all got to get the likes up. Nah, I'm playing. Let me know when you're ready.
Go ahead, start. I don't have it up, but go ahead. I'll put it up in a minute.
Okay, so it says, so this is obviously the United States Eastern District Memorandum of Law in reply to the government's opposition to Robert Sylvester Kelly's motion to dismiss. And it says Farinella Blankbecker. Mr. Kelly respectfully submits this memorandum of law in reply to the government's opposition to Mr. Kelly's pretrial motion to dismiss in advance of the trial scheduled to commence on August 18th, 2021. This motion seeks to dismiss the predicate acts alleged in count 1, numbers 12 and 14, as well as the Mann Act violations alleged in counts 6 through count 9 and in count 1, Racketeering Act 1, Racketeering Act 2, Racketeering Act 3, Racketeering Act 7, and Racketeering Act 10. Sylvia, do you want to watermark it?
Branda's busy.
Okay, well, I mean, you don't have to show it. I could just read
Okay.
it. I don't want people
just
to
read it.
Yeah, I don't want people to steal your stuff. Okay. So then it goes on to say, additionally, Mr. Kelly disputes the jurisdiction and venue in the third superseding indictment filed on March 13, 2020, pursuant to Rule 12B of the Federal Rules of Criminal Procedure. And it says, Argument 1. The motion is timely. This motion disputes the court's jurisdiction and venue. On March 20, 2020, the government, in response to Mr. Kelly's motion to strike, complained that here the government has not presented a full proffer of its evidence. Rather, the government has presented only a limited proffer of the evidence filed in support of its various motions for permanent orders of detention. See ECF docket number 320, page 6. In light of the government's argument in the prior motion, and given the fact that certain sections of the instant application alleged that there is no evidence related to certain allegations in the indictment, Mr. Kelly filed this motion when the government's proffer of evidence should be complete. The Second Circuit has recognized that a district court can adjudge the sufficiency of the evidence before trial where the government has made a full proffer of evidence or where there is a stipulated record. See United States versus De Laurentiis, 230 F3D 659. United States versus Alfonso, 143. Consistent with this rule, the courts have fashioned the following standards to govern a pretrial motion challenging the sufficiency of an indictment. Courts regard an indictment sufficient if it set forth the elements of the offense charged, puts the defendant on fair notice of the charges against which he must defend, and enables the defendant to assert a double jeopardy defense. United States versus Todd, 446. In the alternative, if the court considers the government's argument as to timeliness, it is respectfully submitted that good cause has been demonstrated, and the court, in accordance with Federal Rule of Criminal Procedure, Rule 12, can decide the motion. Part 2. The motion has merit. A. The charges related to herpes exposure should be dismissed. Based on the fact that the government cannot prove the public health law 2307, the reckless endangerment allegations should be dismissed. In the alternative, other case law indicates the infection with HIV is not a serious injury, since medical advances in recent years mean that HIV no longer poses a grave risk of death. People versus Williams, 974 in New York. On other grounds, 24 in New York. If the case for HIV, then herpes should not be, I think they meant in this case for HIV, then herpes should not be judged differently. And then it says, I guess from the previous thing, it says, as stated in the moving papers, venue is clearly established that where the venue is challenged on a pretrial motion to dismiss, the government's burden is limited to showing that the indictment alleges facts sufficient to support the venue. United States versus Peterson. Mr. Kelly is seeking dismissal of count 1, numbers 12 and 14, as well as the Mann Act violations alleged in count 6 through 9, which are the only alleged acts in the third superseding indictment that occurred within the Eastern District of New York. If the court grants Mr. Kelly's motion, it is respectfully submitted that the Eastern District of New York the Eastern District of New York would not be an appropriate venue. As courts have held, the government bears the burden of proving by a preponderance of the evidence that venue exists. If the only acts that have actually been alleged in the third superseding indictment to have taken place within the Eastern District of New York are dismissed, then the government cannot prove by a preponderance of the evidence that venue properly exists in the Eastern District of New York. So then it goes on to say, this was part B, the charges related to herpes exposure must be dismissed. The government has not disputed that herpes is not, quote, an acute bacterial venereal disease such as syphilis or gonorrhea, end quote. The New York State Department of Health stated it is not aware of any instance of an individual being charged with a misdemeanor under Penal Code 2307, Public Health Code 2307. I'm not sure, the NYSDOH further commented and explained, notably, Public Health Penal Code 2307 was added in 1943 to prevent the spread of diseases such as syphilis and gonorrhea to members of the military during World War II. According to the legislative history, the law was amended in 1946 to apply where someone knowingly exposed another person to a venereal infection. Legislative Memorandum 1946, New York State Legislative Annual, page 191. Thus, to the extent that this section of law is enforceable, NY interprets it is inapplicable to individuals who have sexual intercourse where they either one, do not know they are infected, or two, do know they are infected and reveal that information to their consenting partner. Further, the department interprets the law as only applying to individuals who knowingly expose another individual to an acute bacterial venereal disease such as syphilis or gonorrhea. No changes have been made to the regulations in response to these comments. See Exhibit A, page 15 through 16. The New York State Department of Health has unequivocally stated that the department interprets the law as only applying to individuals who knowingly expose another individual to an acute bacterial venereal disease such as syphilis or gonorrhea. It is indisputable that when it comes to the standard of review of a government's agency interpretation of the law, it enforces the courts give deference to the agency's statutory interpretation. An agency's interpretation of the statutes it administers generally should be upheld if not unreasonable or irrational. In this case, the government does not dispute that the New York State Department of Health's position is the department interprets the law as only applying to individuals who knowingly expose another individual to an acute bacterial venereal disease such as syphilis or gonorrhea. Further, the government concedes Mr. Kelly's point by not disputing the New York State Department of Health's position on Penal Code 2307, and stated that the council's response to a public comment is not binding on this court. See ECF docket number 168, page 4. However, the government ignores the established precedent that courts have applied as the standard of review for the agency's statutory interpretation. Therefore, pursuant to the agency's interpretation, Penal Code 2307 only applies to an acute bacterial venereal disease such as syphilis or gonorrhea, and the allegations in the indictment relating to this law should be dismissed. Moreover, the government is wrong because the cases they cite are not persuasive, because the cases are clearly distinguishable from this case. The cases cited are civil cases where the burden of proof is different and do not address this issue directly. Despite the government's citations of New York Supreme Court cases, the New York courts have not been presented with this issue, which makes this a case of first impression. This is evidenced by the New York State Department of Health view of the law. In this case, the government has failed to allege anything other than herpes. There is no distinction between herpes HSV or HSV1 and genital herpes HSV2. If the court accepts this broad interpretation of the government's view of Penal Code 2307, then this would be as if the statute was amended. It would be nothing more than the exercise of power of judicial review to set aside government acts which would be unconstitutional, unduly prejudicial to Mr. Kelly, and it would violate his constitutional rights. If the Penal Code 2307 law is not dismissed, in this case, it will set the precedent that which could potentially lead the government charging expectant mothers who have become pregnant after knowing they have herpes, HSV1, and have knowingly exposed their children to herpes for such exposure. Moreover, when the child turns 18, they could sue the mother for said exposure. Therefore, the courts holding that an agency's interpretation of the statutes it administers generally should be upheld, if not unreasonable or irrational, is for a reason. It would be completely unreasonable or irrational if herpes was written into Penal Code 2307 and when the concept of genital herpes did not exist when the statute was passed. Part C. Count 1 is barred by the statute of limitations. Goes on to say the allegations contained in Court 1 Racketeering Act 1, Racketeering Act 3, Racketeering Act 5 should be dismissed because alleged violations of law occurred outside the proscribed statutory period of time such claims could be made. Count 1 Racketeering Act 1, bribery, asserts the violation of Illinois Criminal Codes sections 533(1)A and 551. Under there is a 3-year statute of limitation for the above mentioned section. The alleged act is to have occurred on August 30th, 1994. The allegation in this complaint was made on or about March 13th, 2021. Sylvia, do you see that? March 13th, 2021. I'm not going to say. March 13th, 2021. This is clearly well beyond the 3-year statute of limitations. Therefore, Count 1, Racketeering Act 1, should be dismissed. Additionally, the general federal statute of limitations for felonies stand for the proposition that the government can no longer file criminal charges for an offense once 5 years has passed. The federal statute of limitations is 18 USC 3282. This statute states, quote, except as otherwise expressly provided by law, no person shall be prosecuted, tried, or punished for any offense, not capital, unless the indictment is found or the information is instituted within 5 years next after such offense shall have been committed, end quote. 18 USC 3282. Count 1 Racketeering Act 3, Count 1 Racketeering Act 1, kidnapping, asserts the violation of Illinois Criminal Code sections 510(1) and 551. Under the Illinois Criminal Code section 720 ILCS 510(1), 720 ILCS 510(2), there is a 3-year statute of limitation for the above mentioned section. Sorry. The alleged act is to have occurred in or about and between 2003 and 2004.
Dom. So the government was saying there's like it's like a whole blanket. There's no statute of limitation, but according to this, there is a statute of limitation. I always
Right.
thought it was a statute of limitation.
There
So
is. Remember, I sent you that video. And so
Mhm.
okay, so this is what they're trying to say. Just I'm gonna stop right there to break it down for you guys. So the government is saying that the statute of limitation, there is a statute of limitation, right? But what they're saying is he was still okay. His defense is saying the charge that they're bringing up, the bribery for the statute of limitations, was in 94, which obviously we're in 2021. So the 3 years has passed long ago, right? Or the 5 years, 3 or 5 years,
Mhm.
right? But
Mhm.
what the government is saying is he still was committing these acts in 2015 or
Yeah, because you remember.
2018, because we
Yeah,
read
because
that last time.
yeah, but remember, they cannot use anything bribery because she knocked that out
Right,
for
right. Yeah, I agree. I agree. So, but that's what I'm just telling you what the government's saying and then what the defense is saying. You
Mhm.
see, so it's kind of a, they're arguing back and forth about the dates and the statute of limitations. You see, for people who, because it's a lot of, reading and understanding. So that's what they're saying.
Okay, go ahead. Sorry.
Okay, so then it goes on to say, the alleged act is to have occurred in or about and between 2003 and 2004. The allegation in this complaint was made on or about March 13th, 2021. This is clearly well beyond 3-year statute of limitations. Therefore, Count 1, Racketeering Act 1, should be dismissed. Additionally, the general federal statute of limitations for felonies stand for the proposition that the government can no longer file criminal charges for an offense once 5 years has passed. So the statute of limitation is 3 years, but the government has 5 years to federally charge you for that particular crime.
So then they way beyond that 5 years.
Exactly. Because
Mhm.
this should have happened no later than for that 94 charge that they're charging him with should have
By
happened
2000.
2000. Exactly.
Yeah.
So it's way past.
Mhm.
The federal statute of limitations is 18 USC 3282. This statute states, quote, except as otherwise expressly provided by law, no person shall be prosecuted, tried, or punished for any offense, not capital, unless the indictment is found or the information is instituted within 5 years next after such offense shall be committed. End quote. 18 USC
So
328.
okay. But here's the deal. Because remember you said the other one was saying that he was still committing those crime, but those crime was never charged.
Right,
Because remember you
right.
said that they saying he was committed, but they never charged him. They should have charged him when they were being committed right afterwards. You know what I'm saying?
Right. No, I'm with you on that. I agree. But that's just what they're saying, though. They're saying that he still was, and it's not that specific. So, okay, let's say I'm just gonna use the bribery, right? They're saying a lot of these racketeering. I'm just gonna say the bribery, for example, right? So what they're saying is, okay, in '94, this is them now, the government. They're saying that okay, he committed bribery to Aaliyah, or whatever, right? And then they're also saying what the government's saying is that if you're still committing bribery, it doesn't have to be with that Aaliyah. It could be with any other person. Then
Yeah,
you can still be charged with that. And they're saying
but
that
you
he was
but
still
they're
doing
saying
bribery.
they didn't he didn't get charged when he was still doing those bribery.
Right. That's what the defense is saying. I'm telling you what the
Yeah,
government is
but
saying.
yeah, I'm saying, but the government has to show proof. Being indicted doesn't mean that you was convicted of it. You
Exactly.
understand what I'm saying?
Exactly.
So
Yeah.
okay,
Exactly. Yeah. It's obviously it's just arguments back and forth, and it's the law is what I mean. I'm going off what the defense is saying. They're saying that that is illegal. I mean,
yeah,
it's not illegal, but
but
it's
but
past.
that makes sense. The only thing that should be not no statute of limitation is if you do capital punishment, if you kill somebody, that's totally different. But
Right.
some bribery, that means forever somebody could keep coming back for a bribery that was done 30, 40 years ago. You can't do that
Exactly.
unless the law changed. The law
Exactly.
has not changed, so you can't do that. Because the law
Exactly.
changed for the statute of limitation for sexual assault, but there has not been changes for bribery.
Exactly. So for
And now
people
some
asking, yeah, yeah. Go ahead, Sylvia.
no, go ahead, go ahead.
No, I was just reading some of the comments, and yeah. So it's 3 years that the statute of limitations runs out. So if I commit a crime right now, they would have 3 years. That's when the statute of limitation goes out. But then the government has an additional 2 years to actually charge you. So really, the statute of limitation really is 5 years because they still can charge you after that three for the next two. So really, it's 5 years.
5 years, but it's way beyond that 5 years still.
Exactly. Exactly. We're
Hmm.
way past that. We're over 10, 20 years later, 30 years later,
They
whatever.
should have did it a long time ago. This is still not the okay.
Exactly. They
Hmm.
should have charged him, way back then if that's what they thought was going on, you know.
Yeah.
Okay.
And remember, they
So,
can't come after him for anything that he was charged with in that case that he was acquitted. Because that's one of the things she said in the thing that they were reading. If he's been
exactly.
acquitted, he can't come back on him on that.
Exactly. They can't even bring that case up.
Up, yeah.
Okay. So, this is argument D. Racketeering Act 2, Racketeering Act 7, and Racketeering Act should be dismissed. 10 should be dismissed. Man, they irritate me, Sylvia.
They are getting on my nerve. They really are.
I'm
Cause
gonna tell you why, but they irritate me.
why?
Hold on,
Tell me why.
hold on.
Oh, the wordings. What we talked? What you just saw?
Look what I
The
said in the private chat. Man, they irritate me. I just didn't want to say it. You know what I mean? I don't want to. But anyways,
didn't I say
racketeering
that
act.
earlier? Didn't I say that
Yeah,
earlier?
yeah. That's crazy. But racketeering act 2, racketeering act
That's because
7,
when you
and
do things at the last minute, you rush, and don't pay attention.
yep, you got to be on top of things. Racketeering act 2, racketeering act 7, and racketeering act 10 should be dismissed. Count 1, racketeering act 2. Count racketeering. Excuse me. Count 1, racketeering act 2, racketeering act 7, and racketeering Act 10, which include the allegation that certain Jane Does, quote, engaged in sexually explicit conduct for the purpose of producing one or more visual depictions of such conduct, end quote. However, there is no evidence that visual depictions exist. I'm going to read that again, y'all. However, there is no evidence that visual depictions exist. Therefore, as a matter of law, and because it is impossible to find the Mr. Kelly of these allegations should be dismissed. Additionally, a victim's uncorroborated statements are not always admissible. The courts have held, quote, further, although a victim's statements are generally admissible, not all statements by a victim are considered reliable hearsay. Unsworn statements of the victim are admissible if there is a requisite indica in indication, I guess, of reliability.
Indication.
Indication of reliability, and the statement is not equivocal, inconsistent with other evidence, or dubious in light of other information in the record. End quote. Conclusion. For the foregoing reasons, Mr. Kelly respectfully asks this court to grant his motion to dismiss in its entirety, dated New York, August 16th, 2021, by Thomas A. Farinella, Nicole Blank Becker, counsel for Robert Sylvester Kelly. Wow.
What's your opinion?
Man,
I wonder who's doing that.
I don't
Come
know.
on now. I don't even know what.
Sylvia, I seen some stuff. It's just crazy. But as far as all in all, the point being, I think they made some good points as far as putting, but it's, I mean, I don't know, it's hard to say, but they do show that the statute basically it's the statute of limitations have passed. That's just period. That's
And she
basically what
hasn't ruled on that yet.
right. So that happened, and then also they also stated, we're just summarizing what happened, guys. So what they're saying is that um, for the herpes, they both charges should be dismissed because, in other words, um, that is not the same as HIV.
Okay, I'm looking at the statute of limitation time for filing charges against a defendant. The general statute of limitation of felonies stands. It is 5 years regardless. It stands.
Yep.
It stands here.
Yep. And she rules on what, Wednesday or what day?
Wednesday.
Wow.
Okay, it says all the majority of federal crimes are governed by the general 5-year statute of limitation. Congress has chosen longer periods for specific crime for years, such as theft of artwork, 10 years for arson, and then certain financial institution and immigration offense. That's it. So none of those stands in that for longer. Did you hear me,
Yeah, I
Dom?
hear you.
Did you hear the specific ones? Theft
Yeah.
of artwork is 20 years. 10 years for arson. There's no fire here, right?
Uh-huh.
Immigration offenses.
Uh-huh.
There's no, and financial institution. Crime against a financial institution. He didn't do a crime
That's
against a
interesting.
financial institution.
That's interesting I'm just being honest. That's interesting that the statute of limitations would be long on those. I guess they taking that money serious.
Yeah, when you're dealing with people money,
Damn.
but it doesn't say nothing about sexual or bribery or
So you
They
heard
say
that, Bozo. You could get 20 years for that
it
damn
says
defense.
it says, well, the vast majority of federal crimes have a 5-year statute of limitation. That means that the Fed have to charge you within 5 years of that crime occurring. Within
Right.
5 years. That's what it says. All crimes, with
Right.
the exception of the ones I just told you.
So that's what I'm telling you. So what the government is saying is that it doesn't matter what on specific person. They're saying that the charges happen, but the defense is saying no. What we're saying is you charged him for in 94. You're saying he did this in 94. So the statute of limitations passed on that. So you can't try to use that charge for a 2012 person. You understand what I'm saying? So basically,
hmm
it's like if you had a 2012 person, then you should have charged him with that 2012 person. Does that make sense? So that's
Yeah.
the dispute. That's the argument on both sides.
Okay. Now, I'm in here reading exceptions again. There's no statute of limitation for federal crime punishable by death, meaning if you kill somebody,
I
there's no
don't think there's a
statute of
statute.
limitation.
Yeah,
There's
I was
no
gonna
statute
say,
of
yeah,
limitation for terrorism,
right.
and then
I figured.
for certain federal sex offense, certain ones, but it didn't tell you which ones. Let's see. Let's see which sexual
I would
offense.
assume something probably like rape. You know what I mean? Like that type of thing would
You think
probably.
statutory rape? But they're not talking about. They're talking about bribery. Bribery definitely statute of
Yeah.
limitations passed on
Well,
that one.
well, they're saying. I mean, they're saying racketeering. I don't have the indictment in front of me, but they're saying count one, racketeering act 2, racketeering act 7, racketeering act
Even
10.
the racketeering is 5 years.
Okay.
hmm
And then
It,
okay, so yeah, so racketeering act 1, or act 3, act 1, kidnapping, assertions, yeah. So they're saying basically the whole racketeering thing.
yeah.
Damn near. I mean, a lot of those counts, bribery, kidnapping, those
Uh,
no. They saying that you got to drop those.
yeah.
And then the herpes, the spreading, knowingly giving it, giving it.
Oh, definitely. That's not going to stand
Right.
because you can't say who gave it to who. You don't know.
Right.
And the way that girl was having sex and people having sex with her, you don't know. I'm talking about when we were talking about Geronda. Remember we read her thing today, her book?
Right. Even
You don't.
even the one lady, the hair braider, she's on there talking about I like doing this and that. I was like, man, she was on TV talking about she likes giving head to dudes and stuff. So it's like some of this stuff is just, it's like, come on, dude. But the feds didn't charge him until 2019. Rhoda. The
They
feds
said,
charged him in 2019. Yeah.
yeah, force of violent sex is what's not there's no statute of limitation.
Right,
Force
but
or
there's nothing like
violence, huh?
right. There's none of that in these
Mm-mm. It
counts.
said force of violence, not statutory. Statutory is not forced.
Right. Yeah, so they're basically asking for, let's say, that's 1, 2, 3, 4, 5, 6, 7, 8. 8 of the racketeering acts to be dismissed. Racketeering acts and the Mann Act. So Yeah, and the Mann Act violations. Yep. So 6 through 9. Yeah. So there's like 15 counts they're asking to be dismissed.
Okay. Here's all the federal charges. You can have money laundering, weapon charges, drugs trafficking, white collar crime, internet crime, child pornography, credit card fraud, identity theft, tax evasion, arson, sexual assault, and trespassing. Those are federal crimes.
Yeah. Yeah. So that's basically. Whew, that's just a lot, man.
Well, that's it, y'all. We can go to bed now. You ready?
Yeah,
There's
that
nothing would surprise you with me. This judge seems like she's pro prosecution. It should be dropped.
Yeah, I mean, I think she's just doing her job at the end of the day, but I do think, I mean, she has to at least see, like, man, she can't just side with the government. You know what I mean? Like, she's gonna do her job, but I think just even them proving this, they need to drop these charges. I mean, it's right there. You know, saying that the statute of limitation has passed. So I don't know.
Okay, forensic says Mr. Kelly was arrested Thursday evening, July 12, 2019. That was initially charged with 13 federal counts in New York.
Sylvia, did you hear the part that I read? I read it twice.
What
Did you
part?
guys hear that part?
What part?
It said, hold on, let me find the part. I said, damn, and this is the defense now, right? So the defense gets all the discovery, right? I mean, it's the trial's in 2 days. It's not like this was 2 years ago, a year ago, and they could say, you know, you can argue that maybe they're just saying that, but they have the discovery, right? This is 2 days before trial. They have all the discovery, and it specifically states, um, it says on the argument D about the Racketeering Act 2, Racketeering Act 7, and 10 should be dismissed. It says count 1, Racketeering Act 2, Racketeering Act 7, and Racketeering Act 10, which include the allegation that certain Jane Does engaged in sexually explicit conduct for the purpose of producing one or more visual depictions of such conduct. However, there is no evidence that visual depictions exist. So they have nothing. There's no videos. There's no
No
tapes.
video, because they even said it. You see, they didn't even debunk that.
Right. There's no tapes or videos, y'all.
Mm-mm. Remember,
That's crazy.
Chicago was waiting on New York, and New York was waiting on Chicago when I was there for those
Right.
videos.
So there you have it. It's no tapes, and that right there is huge. You know, because I mean that they tried to say it was him on the last one. You know what I mean? So with a tape, is it makes
But
things more difficult.
but they can't use anything from the old case because that was already
No, I
that
know.
was
But what I'm saying is though, people thought that was him though. You know what I mean? So what I'm
yeah.
saying is if
I
there's
know
nothing,
that. Yeah,
there's no tape, then you can't say that that's anybody. You can't
yeah,
even give your opinion because there's nothing to view on. You
yeah.
know
But
what I
they
mean?
can't. Even if they came up with the one from the old case, they can't use that one.
They can't. Exactly.
Mm-mm. She
Exactly.
said they can't.
Hey Corey, I mean I feel you. I think she is, but you know, that's your opinion. I think she is doing her job. She has to just do the law. Like she's not on one side or the other, you know, but I do think she has to see that at least some of these counts, something got to be dropped off the simple strength that the statute of limitations and
But
her
you know what the
position.
good thing is? Once they get on that stand, they're gonna fall. They're
Yeah, of
not gonna
course.
stand.
Right. Golden Girl, right. Yeah, I agree,
Yeah,
Mixler.
they're not gonna stand once they hit that.
Do you know the department just has its own press release?
Well, guys, I'm about to go to bed. Randa's live, y'all. We're
Oh, okay.
gonna. I'm gonna
So
go to
I'm
sleep
about to go
now.
to sleep. Yeah, I'm tired.
Me too.
All
All right.
right, y'all. Well, y'all have a blessed night. We'll just
Yeah.
wait
Thank you
till
for reading.
Wednesday.
Oh, Randa
Yeah.
send me it. Hold on, y'all. Randa send me the thing. She sent it to me. I didn't even know she was gonna be.
What, the watermark?
Yeah, she sent it to me.
Oh, okay. Well, yeah. I mean, maybe tomorrow I can read it again or something. You can show it up.
Yeah, I'm gonna show it to you guys tomorrow.
Yeah. Also, what time do they have does the judge have to make her ruling on Wednesday? Is it just when the court starts, or
What time she has court? Let me see what time she has court tomorrow. Hold on, let me look at her schedule, y'all.
yeah, no
And
doubt, Corey. Yeah, no doubt, bro.
this, I'm gonna tell you, by the time this is over with, I'll delete everything having to do with this court stuff.
Right.
My computer is so bogged down with stuff from this court.
Pick up all that's memory. Now, do you think she legally rule tomorrow, or is it
Yeah.
just
She could wait till Wednesday to rule because tomorrow she has cases. She has other cases. She has a case at 10:30, and then she has another case at 11:30, and then one at 12 o'clock.
well, maybe after? I think it'll be before midnight on Wednesday because in the trial, I think that would
Trial
be
is
kind
at
of weird.
9:30. Trial is at 9:30.
Right. You don't think that would be strange, like to come into court, okay, cool, and then she's like, okay, this charge is dismissed, this charge is. I feel like she would want that before the trial starts. That way it's not even, an issue. You know what I mean?
Mm-hmm.
So I'm thinking by midnight on Wednesday. That's just my opinion, but we'll just have to see, I guess.
Well, she's gonna do it before midnight. She ain't gonna wait till last minute. I'll tell you that much with her.
Well,
By
yeah,
the time 5 o'clock close out, she'll have it in.
she'll have it in. Okay, so she'll probably have it in tomorrow. I would say definitely. That way it's
Tomorrow's
before
Wednesday,
tomorrow's Tuesday.
Tuesday. Okay.
Yeah, to get it in before the trial starts, because then that's just a whole nother thing you have to worry about. You know what I mean?
Mm-hmm.
I feel like she wants to just get it started and go in order with how she wants to do it or whatever they got to do. You know. So I guess we'll just wait and see. It's crazy, man. We got 2 days. All right. Well, I'll see you guys tomorrow.
Good night, everybody. Thank you
Y'all have a
guys for
good one.
being here. Have a good night.